And you are representing yourself, correct?
Yes, Your Honor.
All right. Where are we with this case, Ms. Dixit?
Yes, Judge. So I did speak to Ms. Fleming, and she did send us a screenshot of the, arbitration claim that she has submitted to American Arbitration Association. And I was just telling her that we have not, I did check my portal. We have not received any emails or anything on the portal so far from AAA. So I was just telling her, if she would consider possibly withdrawing the arbitration claim if my client considers dismissing the case with prejudice. So that's a possibility that she is open to. So I will be talking to my client about that, Your Honor, so we can kind of resolve this short of arbitration. So that's.
What do you want, an adjournment for a week or so?
I'm okay with that, Judge. So today.
As opposed to what? I mean, if you got another idea, I'm all ears.
Oh, no, Judge, that's fine. I would just say maybe. I know you said 1 week, but maybe mid next week. Would that work? Just so I can absolutely make sure that I have something back from my client, so I'm not here, saying that I have an update.
Jennifer, can we just set this on a Tuesday or Wednesday? Wednesday next week. What day is that? That's the 20th. Well, wait a minute.
20.
What's that?
Yeah, 20. We can't do Wednesday of next week. That's the Christmas Eve.
Oh,
And that's a holiday.
Right.
Well,
Tuesday you've got state.
yeah. So you want me to just move it out another week? I could care less.
that's fine, Judge. I would really appreciate that, just so I can absolutely make sure I have an update.
Okay. And in the meantime, if you two do resolve that, I would hope that you would just send in the paperwork dismissing the case with prejudice with a signed stipulation.
Absolutely.
I'll do it. Jennifer, what about the 5th? Is that still?
You have landlord tenants starting that day.
Well, let's set this one for the 5th, and
Okay.
we'll do it. And we'll do it at
8:30 first
8:30.
thing.
Yep. Okay. Anything else, Ms. Dixit?
Oh, no, just to confirm the date. So January 5th of 2026 at 8:30 a.m. and that would be via Zoom again.
Correct. Ms. Fleming, any questions?
No, Your Honor.
All right. Have a great holiday, everybody. Enjoy your Christmas. Thank you.
Holiday. Merry
Thank you.
Okay. Unsecured financing versus Desiree Perez, Jason Mark, and Dustin Underwood, 2502007.
Your Honor, Matthew Kuipers, I'm here for plaintiff. I'm trying to finish up one last hearing quick from 8:30.
All right. You go ahead and do that and then log back in, okay?
Yep.
JP Morgan Chase versus Lorraine Severance, 2502396.
Good morning, Your Honor. Alfonso Nixon on behalf of the plaintiff. My P number is 83746.
Good morning. And who's here for the
Honor,
defense?
was this Lorraine Severance?
Yes.
Yes, this is James Saig on behalf of Lorraine Severance on JP Morgan Chase versus Lorraine Severance, but I believe Mandarich Law Group was on this, and we had Angelina Abufarha.
What could you do?
Yeah, I'm with the Mandarich Group. She is not available today.
Oh, okay. Because I thought I just spoke with her. I'm sorry about that.
Oh, my apologies. Must be a miscommunication between us.
Oh, it's no problem. Would you like to speak in a breakout room?
Yeah, if that be possible, if the honor would be willing.
Go ahead. We'll put you in a breakout room.
Thank
All
you,
right.
sir.
Thanks so much.
Thanks. All right. Now, unsecured financing versus Desiree Perez, Jason Mark, Dustin Underwood, 2502007. Mr. Kuipers.
Good morning, Your Honor. Matthew Kuipers on behalf of plaintiff.
Boy, this case has been lingering around. Are any of the defendants here, Jennifer?
No, Your Honor. And this is on Jason Mark today. I believe he had filed an answer and this was set for hearing. There's a default copy in there on other defendants.
So Perez was already defaulted, right? Counsel back, a judgment was entered October 29th, correct?
I believe so, Your Honor.
And now I've got, was there proper service on Underwood?
I believe so, but let me triple check that.
Your Smallman is gonna take that.
What did I do?
Your Honor, I can't tell from the documents I have in front of me right now. My apologies.
Jennifer, can you tell?
Judge, I'm looking through all the proofs I have really quick. I'm seeing the proofs for Perez. Dustin Underwood. There was alternate service. I see the first class. I do not see the tacking for Mr. Underwood filed with the court.
Well, Mr. Kuipers, has the summons expired? Yes.
And Judge, today though, this pretrial was set because Jason Mark had
Yeah,
filed an
this is only
answer.
for Jason Mark. Yep.
That's fine, that Underwood's going to end up being dismissed then, right? If we don't have proof of service on the alternate means and I already extended the summons,
I'm looking, Judge, I do see it was attached with one of the Perez groups, October 21st. I do have the tacking
Underwood?
for Underwood. I just do not have like the return certified saying whether or not it was signed for or if it was unclaimed for Underwood. But I have that they say they sent it certified mail.
Your Honor, we can get that to you, to the court.
Well, I mean, I'm gonna need that now. Why don't you get it now, if you would, please? This case, I mean, it's been going on since May. So
I can try, Your Honor. Let me email someone, and I guess if the court wants to pass on this, I don't know how long it's going to take to get the proof of service for the certified mailing.
wait a minute, Jennifer, you're talking about on the alternate service, right? And I
Yes.
ordered certified mail, whether they signed for it or not, if they've got the tacking and first class mail, that's sufficient service,
Yeah,
Okay.
that's what the order said. Okay.
right? I mean, did they do the
Yeah,
other
we
two
just
things?
normally ask for proof that the certified was either signed for or unclaimed. But yes, it's just an extra step that we ask for when they're. But all of them were completed as far as their proofs that they filed with the court.
Well, Mark isn't here. I can give you a default judgment as to him. Underwood, it sounds like service was appropriate because they at least filed a proof of service saying they sent it by certified mail, correct?
Correct.
Okay, I'll give you a default as to both, counsel, if you want to go ahead and
Yes,
put
I
the
do, Your
terms
Honor.
on the
Thank you.
record.
So it's for the complained for amount of $4,667.14. Cost of $321.73. Statutory attorney fee of $75 for a total of $5,063.87.
Since you've already got a judgment against Perez, I'm going to ask you to just indicate this is by default judgment, and the judgment is joint and several versus all parties, okay? And
Will
if
do,
you
Your
can-
Honor.
And if you can send that over this morning, I would appreciate it. Defendants,
Yep, will do.
Mark and Underwood failed to appear for pretrial today, so I'm going to go ahead and enter the default judgment against both of them. Thank you. All
Thank you,
right.
Judge.
JP Morgan Chase versus, wait a minute. Yeah, JP Morgan Chase versus Lorraine Severance, 2502396. Gentlemen, your appearances again, please.
Alfonso Nixon on behalf of the plaintiff, Your Honor.
Good morning, Your Honor. James Syed, P80407 on behalf of the defendant, Lorraine Severance.
Any resolution on this?
Yeah,
No
Your Honor.
resolution.
Oh, go ahead, Counselor.
Yes, no resolution yet, but we believe we will be able to resolve this case. And we should be having some settlement communications within this week. If we could just get dates and maybe 60 days for discovery, and hopefully we'll have this resolved.
Nobody demanded a jury, correct?
Correct.
All right. So I am going to go ahead. Let's see. No ADR, no jury, no settlement conference. I'm putting down 1/2 hour for trial. I'm going to have discovery cutoff will be, let's see, February 15th of 26. This witness list due January 15 of 26. You don't have to file a trial brief if it proceeds that far. If you choose to, you have to file and exchange it not later than 7 days before the trial date. I'm going to give you a trial date now. Why don't you make it the end of March? And I'm just going to ask that we make sure that you're available, because I really don't care to adjourn this any longer. What do you have for me, Jen?
March 24th at 10:30.
March 24th at 10:30, gentlemen. Okay. Is that good for everybody, Mr. Syed?
Yes,
Yes,
Your
Your
Honor.
Honor.
Thank you.
Mr. Nixon?
Yes, Your Honor.
All
Absolutely.
right. We'll send this out. You guys have a great Christmas, and
You as well, Your Honor.
have a happy holidays. Good luck. Thank you. Enjoy.
Thank you, Your Honor.
Your Honor. Thank you,
Goodbye.
Counselor.
All right. So Cindy. So this one will be yours. Okay, portfolio recovery versus Compton. 2503823. Portfolio.
Your Honor, I have not had either side appear. I've called plaintiff's office and had to leave a message for their legal department, and I've not heard anything back.
And we don't have the defendant's lawyer here out of Philadelphia.
No, I have neither party.
Why does it always seem like out-of-state lawyers do this? I mean, you can't, unless we go fly a plane there and pick them up and bring them in. I don't know how much better we can do. Emily Watson Baldwin, Barbara versus Barbara Ann Pender Tillo. So you have to take your hat off, sir. 20B8284.
The podium here.
Good morning, ma'am.
Podium.
You both have lawyers, right?
This is a post-judgment discovery subpoena, so this would,
I see. Thank you. Okay, what is your name, ma'am?
My name is Emily Baldwin, but recently I got married this past weekend, so my last name is not Watson.
Well, congratulations.
Thank you.
Hope it's a long and healthy and happy one. Ma'am, you could come up here. If your knee is hurting, you want to sit down, I don't have a problem. What is your name?
Barbara Willett.
Formerly Barbara Ann Hendertillo? Okay. All right. Did you bring all these documents with you?
Yes.
Have you guys sat down and talked?
No.
So if you, go ahead.
Just over text messaging, and we were back and forth because I got the okay from her lawyer or her attorney to message her when I received payments or have not received payments. So I would message her, just say, well, hey, I haven't received anything yet. And I do have some text messaging going back and forth with that.
All right. Let me ask you a question. What was the amount of the judgment?
$11,000.
And how much has been paid on this?
Well, now she's up to date, except today, a payment is due today, but I haven't. It was not like that when I originally, but like had all this going on again. So she was about 3 months behind Your Honor.
Okay, wait 1 second. Just wait 1 second. Is there an installment payment order in effect, Jennifer? Yeah,
There was, but is no longer in effect.
because it was
She-
set aside back in
Correct,
September.
plaintiff. Correct. Plaintiff requested it to be set aside.
All right. So what I can do is I'm going to go ahead and swear you in, Ms. Hendertillo. I'm sorry. What is it again now?
Will it now?
Willett, Willett.
Yes.
So I can swear her in and then you guys can go in the back. He'll take you to, my court officer will take you to a conference room and you can ask her questions under oath, okay? About her assets, where she works, et cetera. Fair enough? You understand?
Yes.
And you understand that? Yes?
Yes.
Okay, I'm going to ask you, Ms. Willett, to raise your right hand. You solemnly swear or affirm on the penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Do.
Okay, so here's what I'm going to have you do. You two walk out in the hall. He's going to take you to a conference room. When you're done questioning her and she's turned over all the documents that you have, you come back in here and just tell me, yes, Judge, everything went fine, or whether any issues develop. All right? Okay, both of you? All right, thank you. We'll see you back here in a few minutes. Take your time. All right. And I still don't have portfolio recovery versus
Correct.
Compton. Midland Credit versus Amber Rennie. Amber Rennie, 2503859.
Morning, Your Honor. William Hill, P 28608, appearing on behalf of Midland Credit.
Good
Good
morning.
morning, Your Honor. Jocelyn Oy, P64890, on behalf of Miss Amber Rennie.
Do you have any pre-trial orders down there? Is there any resolution on this to begin with?
No, Your Honor, we'd like a 60-day discovery order. I think we're going to have a chance to settle this case. I
Okay.
understand an offer has been submitted. It hasn't been reviewed yet by Midland.
All right. Give me 1 second here. All right. Two 28608. You've been around a while, Mr. Hill.
Yeah.
I'm not far behind you, I don't think. All right, so I'll give you guys discovery. We're gonna make discovery open until February 15th of 26. No ADR, no motions date of trial. All motions for summary have to be filed and heard not later than 20 days before the trial date. I'm going to not have a settlement conference, obviously. We're going to set witness list due date as January 15 of 26. January 15 of 26. You don't have to file a trial brief. If you choose to, you have to file and exchange it not later than 7 days before the trial date. No voir dire. Obviously, we won't need dates for voir dire, or I'm sorry, documents for jury instructions or anything. Let's see, what else do I have to cover? Jennifer, I'm going to take the same date for trial.
Absolutely. March 24th at 10:30.
March the 24th of 26 at 10:30. Is that good for you, Mr. Hill?
Yes, Your Honor, it is.
Ms. Am I pronouncing that? Is it Uy?
It's Oy.
Oh, I'm sorry. My apologies.
You're fine.
Is that a good date for you?
That's fine, Your Honor. Thank you.
All right. Merry Christmas. Happy holidays, everybody. Have a great day. Thank you very
You
much.
too.
We'll
Merry
get this
Christmas.
order out the next few days.
Thank
Thank
you,
you.
Your Honor.
Thank you. Okay, now. Okay. All right. Jeffrey Twardzik versus Priority Waste, 2503946R. Mr. Twardzik, your name?
Jeffrey Twardzik, Your Honor.
Mr. Dillon?
Good morning, Your Honor. Alex Dillon, being on behalf of Priority Waste.
Okay, I think you go ahead.
Yeah, Your Honor, we've settled the case. We have, I have to get him a check for $658. And we'll work with the city for another 500. And,
You kind of broke up when you said the amount, Mr. Dillon. I'm sorry.
so the case is settled for $1,158. We're gonna pay $658. The city has said they'd pay $500. One way or the other, we're gonna pay $1,158 and dismiss the case. So if you'd like, we can come back in 30 days to confirm for a review.
Well, you're agreeing to pay your client's going to pay the 1158 if the city isn't willing to pay the other 500. I don't know anything about the case, but that's accurate.
Beyond a reasonable doubt that on or about November 10th, 2024 in Deerfield Township, Warren County, Ohio, the defendant was the driver of a vehicle that was stopped related to a theft investigation. It took a while for him to pull over, but he eventually pulled into a Shell gas station. The rear passenger eventually fled the vehicle on foot. The defendant did stay and cooperate with law enforcement. That vehicle was found to be entered as stolen through the Westchester Police Department, and the defendant did not have information for law enforcement of where he had obtained that vehicle.
Mr. Lewis, anything on those facts?
Respectfully waive further reading, stipulate to what's been read in the record, Judge. Nothing more to add.
Okay. Mr. Baker, did you hear the statement that she read?
I did.
You admit and acknowledge that what she said is true?
Yes,
And again, you understand all the rights you're giving up entering a plea of guilty, the rights we discussed?
I do.
And what is your plea?
Guilty.
All right. The court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Now, Mr. Baker, I'm going to order a pre-sentence investigation, and we'll come back in a few weeks and do sentencing at that time.
Okay.
I do want to commend you. I know that we had a talk one time a few months ago about your attitude, and it's been reported to me that that has greatly changed, and I appreciate that.
Thank you, Your Honor.
All right. Is there anything else, Ms. Nicholson?
No, Your Honor.
Judge T, thank you very much, and also thanks for the consideration Friday. I mean,
All
have a great, happy holiday, everyone.
You too.
Yep. Merry Christmas.
Merry Christmas, Happy New Year, and all that.
Oh, I see what you're saying. There was a
Are you talking about the ILC report that was done?
yes.
So I talked to Ms. Kasurk this morning. I think she intended on emailing you. That was done in May, and so I think she's just going to update that rather than redo a whole new.
Right, and that seems appropriate.
Yes.
Okay.
Yep. I think that's the plan.
So, was he not eligible for ILC? Is that what
I think the court indicated that it was not based on
let me check my notes.
a history.
Because
going
this
to
is
grant
kind of
ILC.
old at this point.
That's what my notes reflect.
Okay. I apologize, Mr. Lewis.
Oh, no
I'm
worries, Judge.
just trying to figure this out.
I appreciate it.
Yeah, let's get the ILC assessment updated. Let me see if I put down that entry because
We had discussed that too, Judge. He appreciates that.
motion entry. Okay. All right, we're good.
Thank you,
All right,
Judge.
thank you all.
See you guys later. Also, Judge T did say my brownies.
Yeah, yes.
Well, why don't we even need to do that? I'm just gonna, do you agree to that amount, Mr. Twardzik?
Yes, Your Honor, I do.
So you understand that this would essentially involve a release of any and all further claims that you have against the plaintiff arising out of this event, transaction, or occurrence?
Yes, Your Honor, I do.
All right, so he's good. Why don't you just, do you have any problem with Mr. Dillon signing your name? He's not going to do that until he cuts the check, and sending in a stipulation in order to dismiss the case with prejudice, meaning you can't bring this action again.
Yes, Your Honor.
And that will be for 1158. So he has your permission to sign your name to that document, correct?
Yes, Your Honor, he does.
So why don't you guys, you can cut that the next week or so, right?
Yes.
Good enough. Jennifer, just diary it up to January 5th, and I'll just expect that we have the paperwork.
Okay, I'll just put it on for review in the morning just to keep
Right.
track of it.
Okay,
Good.
you guys have a Merry Christmas if I don't see you, and happy holidays and everything.
Yes,
Thank
Your
you
Honor.
very
Same,
much.
same to you. Thank you very much.
Thank you
Thanks.
very much, Judge. Well done. We'll talk to you soon.
Thank you, Judge.
Thank you.
Thank you, Mr. Dillon.
Okay, what else do I have here? They're still not here on portfolio recovery.
Correct, Your Honor. And I've not gotten a return call.
Well, I don't know what to do. I'm not going to keep calling cases if people don't show up. I mean, this is crazy. It's 9:15, 9:13, it was scheduled for 8:30. Which, did you call this 594 number, 5091?
I
or
called
did you-
plaintiff's office, Your Honor.
Try this number, will you please? 800-594-5091. And then try the defense office to 248-621-4594. Okay, will you do that for me,
Yes.
please? And I'll just put that file aside for a little bit. Mohammed A. Hazima versus Feldman Dodge Jeep Chrysler, 2504578. Okay, gentlemen. Your name, sir,
Mohammed Ali Azim.
and your name, sir?
My name is Jason Coulter, representing Felon on Board.
Okay. Can you spell your last name for me?
COULTER.
All right. I got to make sure I understand this claim here. Just give me 1 second here. It's in small claims. Total amount is $1750. It says 1988 Buick Regal, driver's side damaged.
Rear.
What's that?
Rear.
You said,
It's in the rear.
okay,
The driver rear.
all right. Need, I can't read this, sir. Need frame body pulled out. He did not do before painting something in the back and my tail light. I can't, you're gonna have to tell me what the claim is
I
about.
will.
Okay. Tell me very briefly what the claim is for.
The claim is for, I went to an hourglass
I
guy.
don't want you to make it long, sir. Just tell me what you're trying to tell me and the reasons for the
Okay, I
claim.
took the car to him. I told him the rear ass have to be pulled on the frame, have to be pulled back and pulled off to get that ding out. So, because I have a light bar, one piece light bar that fits I have to be square. If it's not square, if you overtime it, which he did, and he grabbed my tail light, and because he never pulled it. And when I,
All right,
okay,
all right. You two want to go out in the hall and talk about this, or do you want to just proceed?
This was not in the development group itself. This is a gentleman that he works for me. There's no RO and authorizations between him and the guy that fixed his car. The guy works for the dealership, but nothing was done with the company at all. So his claim against Feldman is irrelevant because there's no paperwork, no sign of notation, no documentation, nothing. It's a side job that went south, basically. So he's suing Feldman, even though the guy did it on the side.
Well,
So the case is being dismissed.
all right, slow down. I have to tell you before we go in this, before we proceed. By proceeding in the small claims division, you're both giving up certain rights. You don't have to proceed in the small claims division. If you proceed in the small claims division, both of you are giving up your right to a jury. Both of you are giving up your right to be represented by a lawyer. Both of you are giving up your right to appeal my decision. Plaintiff is giving up the right to seek in excess of $7,000. If you want to preserve any one or more of those rights, you just tell me. I'll listen. Don't interrupt me. If you want to preserve any one or more of those rights, just tell me. I'll remove the case to the general civil division, in which case you can hire a lawyer. You can appeal my decision if you don't like it. You can demand a trial by jury. And to the extent that you're entitled to it, plaintiff can seek in excess of $7,000. Do you understand everything I've said, Mr. Hazimi?
it was only $1,750.
I know.
Okay. Yes, I do.
Do you understand everything I said?
Do.
Do you wish to give up those rights and proceed here, or to have the case removed to the general civil division?
No, I have to proceed here.
You waive those rights?
Yes.
All right, raise your both of you, raise your right hands. Solemnly swear affirmative penalties of perjury that the testimony you give in these proceedings will be the whole true self you got. Mr. Hazimi?
I do.
Mr. Coulter?
I do.
And what is your position there at Feldman?
Collision director with the corporate team.
Did you take the car into Feldman?
Yes, sir. And it was done at the deal.
Slow down.
Yes.
I thought you said he didn't take the car into Feldman.
There's nothing, no documentation that was ever there. No proof, no paperwork, nothing.
What? You took the car into Feldman. Did they give you some kind of a written estimate or hang on? Or a description as to the type of work that needed to be performed?
Description by word. I told him what I want done. He said, I'll do it. The reason why I took it over there, Your Honor, because there was at the dealer, they had the down draft booth. It was a team, him and his wife. And I got to know him. He said, okay, brother, I'll take care of you, whatever you want. And he told me.
Who's he? Let's talk about who he is. Who is he?
That's Joe.
Joe who?
He goes by Joe or Joseph. His name is Joseph.
Do you know his last name?
No.
Why didn't you sue him?
Because he was at the dealer and he won't even give me the time of the day when I was calling.
Who's Joseph? Do you know?
He was an employee of mine.
Where's Joseph?
He was unable to hear his story.
Where, why?
Because of the suit is not against Feldman, it's against Joseph directly.
I want Joseph here. They didn't give you any paperwork?
He didn't give me, he said, once you get the job done, then I will give you a bill. When the job was done, I told him my vision is not too good. And I didn't see the light was cracked until I washed the car. Then I didn't see the lights. I took pictures of them.
Did you pay this, Joseph?
Yes, I paid him in cash.
At Feldman?
Yes. And he took it. And I gave him $150 bonus. He said, thank you. Now I could buy a Christmas present. Easter present for my son. I appreciate you, brother. Thank you.
What is going on here? Hang on a second. Slow down. What's Joseph's last name?
Parker.
Maybe you need to sue Joseph Parker too. Do you see what he's telling me?
Yes.
Hang on.
I did not know.
Hang on.
I'm sorry.
Stop, time out.
I'm sorry.
Who goes into a dealership and pays cash and walks out with no paperwork? It doesn't make any sense to me.
No, but he did it at the dealer, and he said, I will give you a receipt once everything is done.
You need to add Mr. Parker as a defendant here. And then we'll get to the bottom of this, okay? You can file an amended affidavit. Have that served on Mr. Parker too. It will remain Feldman and Parker. You can add Joseph Parker as a party defendant. Either way, Joseph's coming in here. Okay? Sounds like he was trying to make money on the side.
Yeah, it was.
Well, the problem is you got, I don't know if he held out as that he was doing this for Feldman or not. And certainly he had the right to assume that he was. If he goes there, the guy's got Feldman clothes on. Well, that doesn't mean that Feldman's off the hook here, is what I'm trying to tell you nicely. Here's what you're going to do. Listen very carefully. You're going to file an amended affidavit and claim.
Is that me?
I'm sorry?
I have to file?
You want to bring in this other guy as a
Okay.
defendant. If he's trying to tell me that this guy was doing it on his own.
He did it in the dealer.
I'm just trying to tell you what I would do if I was you.
Okay, I didn't know you were talking to me. I'm sorry.
Yeah. No problem. You want to file an amended complaint, affidavit and claim. Couldn't be here. I have a feeling he doesn't want to be here.
He will come in RP, but when it was addressed to Feldman, and he doesn't represent Feldman, I do. So
Well, he's the one with knowledge of the facts and circumstances of the case.
he is, you're right. You're
I
right.
know I am.
So he's no problem coming in. It won't be an issue at all.
Maybe in the meantime. So you're going to add Joseph Parker as a party defendant. So your claim is going to be against Feldman, Dodge, Jeep, Chrysler, and Joseph Parker. Okay? And then I'll get to the bottom of this.
Judge,
All right.
he's going to have to have Mr. Parker served, so he'll need an address.
Right. Well, you can serve him you can get him served over at Feldman. You can have him served at Feldman. I mean, that's fine. It's not like a courthouse. So let's just set a new date. And maybe in the meantime, Mr. Parker and him can talk, and maybe they can resolve it. I'm gonna give you a new date. Just wait. I think we need to go to like the 3rd or 4th week of January.
We could do the 13th, Your Honor, but the 27th, we have a full day trial.
What about the 20th? Am I here?
That's probation. But if you want to,
Yeah, I want to make sure he gets this filed, served. I mean, we could try January 13th. At what time? 8:30? Or you want another time?
I guess, let's do 10 o'clock.
I'm surprised he's still working at Feldman.
Trying to get the bottom of myself and do it. I'll see it transfer to the EST.
If you get to take cash and don't turn it over to your employer, well, I got, January 13th, you go down the hall. You're gonna fill out amended affidavit. You're gonna add Joseph Parker.
Could you write it down for me, please?
Jennifer, Parker. You know what I'm telling him to do, right? Obviously. So just have him fill that out, and then you have to have Mr. Parker served. Okay?
Can I say something, please?
Yeah, as long as we're not going to talk about the merits, because we're not resolving this today.
Mr. Parker, when I went to him to tell him Why'd you crack my taillight? Why didn't you pull the frame? He comes out from the dealer. He walks to me, sir, Your Honor. He goes, if you ever come back here, I'm gonna break both of your legs.
Oh, really? Now we got us stressed now, DMV.
Exactly. And that's why I came.
You hang on. You take and you have a process server serve this. Okay? You don't go in there. If he's threatening you, I don't want to send you in there.
I don't want to deal with him.
And tell Mr. Parker that if I find out he's threatening this gentleman again, I'm calling the police. Okay? You got it? God, who does he think he is? I'll break
The cops, I mean. And I had the
Who
reporter.
called the cops?
They did.
Feldman?
Yes, because I went to talk to Joel about my car. Why didn't he do it right?
Well, Mr. Parker, he's gonna have a lot of answers to give. Okay?
Understood.
And if you tell him you better not contact this guy, this gentleman, between now and the court date.
I don't have no enemies.
It's fine.
No.
It's fine. It's fine. I don't like
It's
that.
official.
I don't like that threatening stuff. It's not gonna go on. Okay? If it goes on again, you call the police. I'm just telling.
He called it first and.
I don't care what he did.
Up here.
I don't care what he did.
And I'm
I
not.
can't believe it. If Feldman would tolerate an employee, if that happened, I'm not saying it happened, but if that happened, I can't believe Feldman would tolerate an employee talking to a customer like that or any other member of the public like that. If that happened, I'm not saying it did, but I'm not saying it didn't either. And if he did say that, you know what I'd have him doing? He'd be out the door in about 12 seconds. That's all I want to say about it. I'll see you guys on the 13th. Go down to the civil department. Thank you.
Thank you, Your Honor.
Besom Sajdini versus DeWitt Building and Construction, 2504454.
Right there voting.
What's your name, sir?
My name is Alex Hassan.
Can you spell your last name?
Excuse me, HASAN.
And it's Alex, correct? And are you for DeWitt Building?
Yes, I am.
What is your position with them?
I'm one of the owners.
Okay. You have knowledge of the facts and circumstances of this case?
Yes, I do.
And sir, your name?
I'm Alan Sadini. I'm the son of Basim Sadini.
You're his son? Okay. What is your name, sir?
Basim Saidini.
Can you speak English well? I just want to make sure. You got a little bit of a broken.
No problem English. Yeah, it has a little bit of hearing problem.
Okay. I just need to make sure that you can speak English and you understand everything. Do you understand everything?
Satisfied with the representation that you have received in the case?
Yes, sir.
You're going to be entering a plea of guilty to one count of felonious assault. This is a charge with which you are going to receive both a minimum and a maximum penalty. It's what we call a Reagan-Tokes sentence. So if, for example, I sentence you to the maximum penalty, which is not going to happen, but if I did sentence you to the maximum penalty, you would receive 11 years in prison, but then you would also get a maximum term of up to 16 and a half years in prison. That means that the adult parole authority would have the ability, if you don't behave yourself, to extend your prison stay. It's presumed that you are released at the minimum term, but like I said, the Department of Rehabilitation and Corrections may, under certain circumstances, keep you up to the maximum penalty. If I were to impose the minimum sentence on you, which is 3 years, that would be 3 to 4.5. Again, presumed release at 3 up to 4.5. That only applies, though, if you serve your entire sentence. There is a box on the form called Reagan-Tokes indefinite term. It's checked. Did you read that over with Mr. Brenner?
Yes, sir.
All right. Do you have any questions about that?
No, sir.
All right. You're also going to enter a plea of guilty to one count of failure to comply with the order or signal of a police officer. This is a third-degree felony punishable by up to 60 months in prison. And we have an obstructing official business. This is a fifth-degree felony punishable by up to 12 months in prison. and a misdemeanor operating a vehicle under the influence. We also have an agreement that the state agrees to recommend no more than 6 years in prison. The failure to comply and the other charges have to be served consecutively. That's also part of the requirement. We have a mandatory license suspension of anywhere from 3 years to life, and we have a mandatory fine in the amount of no less than $715. You're also subject to a mandatory period of post-release control of anywhere from 2 to 5 years. Before we go any further, Mr. Lunsford, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. View, was the state able to confer with the victim prior to today's hearing?
Yes, Your Honor. We've spoken with Deputy Fox and discussed with him the plea offers that have been made and the potential resolutions, and he's in agreement with the recommendation.
All right, what are the facts?
Your Honor, if the case were to proceed to trial, the state would produce evidence beyond a reasonable doubt that on September 9th of 2025, beginning in Franklin Township, Warren County, state of Ohio, and continuing course of criminal conduct into Hamilton County, that Warren County Sheriff's Office Deputy Troy Fox attempted a traffic stop of the defendant for unsafe equipment. He was driving a vehicle with only 3 tires. The defendant, after lights and sirens were activated, the defendant accelerated away at speeds of over 70 miles per hour on State Route 123, driving into oncoming traffic, eventually drove southbound on I-75, at times driving onto the shoulder. He had a damaged vehicle, was continuing to create risks and hazards to roadways. Parts of his equipment were breaking off and striking vehicles. At one point during the pursuit, he swerved towards Deputy Fox in an attempt to strike his cruiser, an attempt to cause physical harm to Deputy Fox during the course of his official duties. The pursuit continued southbound until the defendant's vehicle was disabled. He refused to exit his vehicle after numerous commands until beanbags had to be shot into his vehicle. He was then taken into custody. Based upon his behavior and demeanor, erratic nature of his conduct, it's believed that he was intoxicated. Found within the vehicle was a nearly empty bottle of whiskey and Suboxone strips. Defendant refused field sobriety tests and a urine test. He has a prior OVI within the last 10 years.
Anything on those facts, Mr. Brenner?
No, Your Honor.
Mr. Lunsford, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. Not going to go into the matter of the sentence today. We're going to do a level 2 pre-sentence investigation, also a CBCF evaluation. See everybody back here in about 6 weeks.
Thank you, Your Honor.
Thank you, Judge.
All right, and I'll keep you posted.
Corrections or any objections? Okay, thank you. There are objections, well, from the people regarding guidelines, but Mr. Mahoney, any objections to report other than that?
Other than guidelines, no objections, Your Honor.
All right, let's hear regarding the objections. I believe it's OB 419.
Yes, Your Honor.
Go ahead, sir.
So, Your Honor, the people objected the MDOC scoring of OB 4 and 19 at 0. The record supports 10 points each, which would raise the OB level from 1 to 2. and the people are requesting that the corrected guideline range be applied. Although there is an updated sentencing information report which places the defendant in PRB level F, accurate scoring of OB4 and 19 remains required and relevant for the court's sentencing analysis, as those variables reflect the seriousness of the offense, conduct, as well as the harm to both the victim and the judicial process, independent of the defendant's prior record. We would just make a note to clarify the record, Your Honor. The court mentioned that the conviction was for witness intimidation, however, it was for witness retaliation. Yes, you are correct. So, Your Honor, as to OB4, the legal standard, OB4 is scored at 10 points if serious psychological injury occurred, and pursuant to MCL 777.34 parents 2, the victim does not need to seek treatment. Under the cases cited in the people's filing, Davenport, symptoms like fear, anxiety, sleep disturbance, and the like support 10 points. And in People v. White, fear alone has been found to be insufficient. However, fear plus ongoing impact is enough to score 10 points in OB4. The record supports the fact that there is ongoing impact to the victim. The victim impact statement that's included in the sentencing information report.
I don't see any at this time. For that reason, I would object to removal of the monitor.
Mr. Helbling, anything that's other than what's in your motion?
We would just request that the monitor, the GPS monitor, be removed too. Thank you.
All right, I am going to remove the monitor. I am going to continue that Mr. Lynch be supervised by pretrial services, including random drug screens. And it's my understanding we're going to set this in a couple of weeks, right?
Yes, Your Honor.
Yes, Your Honor.
All right. Mr. Lynch, you need to head back down to community corrections to get converted over to pretrial.
Okay. Did you catch it? Yes. Okay. Thank you, Your Honor.
Thank you.
See you outside. I'll be right there. Okay. Did you catch what just happened?
Indicates that the victim has continued to feel scared and worried that the defendant or his friends are going to continue to retaliate even after the initial event took place. This reflects the ongoing fear and concern and not a momentary reaction. And ongoing fear of retaliation is a continuing psychological impact under both Davenport and White. And therefore, the people submit that OB4 should be scored at 10 points. As to OB19,
just hold on for just a moment.
Yes, Your Honor.
You scored OB4 at 0, is that? And your explanation?
Your Honor, in regards to the victim's impact statement, it had talked about his fiance, and my understanding is Ryan Giver was the victim, and I did not see where he obtained treatment, and there's psychological treatment, therefore I did not for it.
All right. And that was my question, Mr. Fahani. Isn't the victim in this case the gentleman who was approached and pushed at the bar?
Yes, Your Honor.
So how do you tie that into the individual who had the PPO?
So, Your Honor, the testimony on the record at time of trial also indicated from the victim that his own routines and basically his willingness to go out and enjoy an evening had changed as a result of this incident, because he testified that he feared what would happen if he were to meet the defendant in public again. And therefore, he testified on the record at trial that his routine had changed as well as a result of this incident, and that he didn't even feel safe going out for fear of running into the victim again or the defendant again. So there's not necessarily a tie to the protected individual under the PPO, but I'm speaking specifically of the victim himself and the results of this particular incident.
Ms. Tipp, your response.
I would agree with Ms. Evelyn in regards to OB or being scored at 0. The victim said what he said, however, I don't buy it. I think that they have been going out, they continue to go out. Putting themselves in these situations as well. So I don't think there's any basis for scoring points for that variable.
Mr. Fahani, you made the objection. You get the final argument out.
Your Honor, the record is clear, as well as the supporting case law that indicates ongoing impact. The victim testified to the same, and therefore we believe 10 points is an adequate score.
Very well, thank you. As to OB4, psychological injury to a victim, the court, the standard that has been applied is preponderance of the evidence in this case. And 10 points would be scored if serious psychological injury requiring professional treatment occurred to a victim pursuant to MCL 777.34, parentheses 1, parentheses A. The court heard the testimony of the complaining witness in this case, the victim in this matter, regarding an incident that occurred at a local establishment. And after reading the victim impact statement, reviewing the appropriate case law in this case, court finds preponderance of the evidence that OB4 is properly scored at 0. The objection is respectfully denied. OB19.
As to OB19, Your Honor, the legal standard would be 10 points scored where the defendant interfered or attempted to interfere with the administration of justice. Pursuant to the case law cited in the People's Filing, People v. Barbie, the administration of justice is interpreted broadly. People v. Passage indicates that threats to a witness do qualify as interference with the administration of justice. And People v. Hershey focuses on conduct that hampers or hinders judicial processes. The record supports the fact that the defendant told the victim, "You're a dead mother blank," and also that there was going to be a reckoning for the victim having testified against the defendant. These threats were directly tied to testimony from a personal protection order hearing before this honorable court. That PPO hearing is a judicial proceeding. Threatening a witness because they testified interferes with the administration of justice because retaliatory threats undermine the system by deterring future participation. And therefore, Your Honor, the people argue that OB19 should be scored at 10 points.
Thank you. And you scored it at 0. Is that your explanation?
I did, Your Honor. I am reviewing OB19 and the guideline book. I didn't believe that it met the criteria. I'll leave that up to the court.
Your response.
Correct. The hearing had already taken place, so Mr. Riggs' actions did not interfere with anything in regards to that judicial process for that case. So I don't understand how it would be, how that you would be subject to 10 points with OB19. The hearing was already completed. That basically the intent that Mr. McNally had stated. That's the reason why he was charged. And I feel like we kind of went backwards on a situation that's already taken care of and done. So I would ask the court to deny that request of all those.
The legislature has created this offense because of the fact that retaliatory threats undermine the system by deterring future participation. If individuals believe that others can threaten a person or after having testified in judicial proceedings, then this creates a chilling effect for individuals in the public because they don't want to go to court because they're afraid of what might happen from defendants like this who retaliate after the fact. And that's why both all Barbie, Passage, and Hershey include this offense as a potential for scoring of 10 points in OB19.
Thank you. OB19 is threat to security or penal institution or court or interference with administration of justice. 10 points would be scored if the offender otherwise interfered with or attempted to interfere with the administration of justice or directly or indirectly violated a personal protection order. Well, here we have a situation where a personal protection order was entered against the defendant by the victim's significant other. After the personal protection order was granted, there was this incident that occurred at a local establishment, or already established, essentially what it was about, and the comments that were made. One side made the comment, "You're a dead blankety blankety blank." On the flip side, the defendant's statement was essentially, "You'll have your day of reckoning." I don't know what that means. It could be terrible. It could be something different. The court doesn't know, but that's what the court had relative to the testimony presented in open court. Ms. Sid makes a good argument pertaining to the issue of, well, wait a second, how is this interference with the administration of justice? The testimony was before PPO was entered, and now we're here on the criminal conviction. I agree. I don't believe OB19 is, I think OB19 is properly scored, considering Barbie and all the other cases, but under the circumstances here, I just don't see how it would fit threatening the administration of justice after the PPO was entered. The objection to OB19 is respectfully denied. Ms. Tipp, is there anything you'd like to say to ask your clients before you close the hearings?
That's right, thank you. So I didn't have a chance to go over the recommendation.
Your client keeps raising his hand.
May I say something, Your Honor?
You need to listen to your attorney, sir.
Thank you, Your Honor. In regards to the recommendation and with the guidelines, the recommendations of the year county jail, I would ask the court to consider going with the lower end of the guidelines and to consider that Mr. Grady has been dealing with a lot of medical issues lately. He has a doctor's appointment scheduled for January 6th of next year. I ask the court that any report date be after that date. He does have reservation.
After when? I'm sorry.
January 6th of next year. So he's dealing with a lot of pain right now with his rib cage, his ankle, a lot of it has to do with that. So I would ask the court to consider that. Also, Mr. Grady has been on bond for quite some time. There hasn't been any bond violations or any issues there, so I ask the court to consider that. In regards to Mr. Grady's prior criminal history, we acknowledge it's lengthy and whatnot, but it's so long ago. Not to say that's not relevant, but I would ask the court to consider the amount of time that has gone by without a serious offense being committed by Mr. Grady. Also, Mr. Grady is gainfully employed. I would ask the court to allow work release if the court doesn't order any upfront jail time. But again, I would ask for the court to consider either a later report date or even the first sentence for Mr. Grady, given the situation and his way of health is going right now.
Mr. Grady, is there anything you'd like to say?
I just wanted to show you my medical file to just prove that I'm in due for surgeries and all kinds of stuff coming up. And January 6th is they're going to take a screw out. Hopefully, let the nerves and tendons do something so I can feel it. I'm supposed to walk with help, but I thought I'd walk in here on my own power today.
Anything else?
I'm asking for a deferred sentence, like hold the time over my head after 18 months of probation or something, but let me get healthy before I gotta go to jail. I'm in pain standing here talking to you.
Thank you.
You know.
Anything else?
No, sir.
Mr. Pahani, anything on behalf of the people? This is a victim's rights case.
It is, Your Honor, and I don't see Mr. Gibbard in the courtroom today. Your Honor, the guidelines in this case are 10 to 46 months. The Department of Corrections has recommended 365 days in the county jail, but people submit that a prison sentence is both appropriate and necessary in this case. The offense here is not about isolated words. It's about retaliation against a witness and contempt for the court process committed by a habitual fourth offender with an extensive criminal history. This is not a single incident. These were not words that were spoken in frustration. The record does not support that framing. The defendant expressly threatened the victim because he testified against him in court. The threat was explicit, it was personal, it was tied directly to participation in a judicial proceeding. And that is not momentary frustration. That is retaliatory conduct that strikes at the integrity of the justice system, Your Honor. This wasn't venting, this was punishment because of testimony. The legislature has classified this offense as a Class B person offense. It's punishable by up to life in prison, enhanced here by the habitual offender status. And retaliation against a witness is among the most serious nonviolent offenses because it undermines this court's authority, it deters future witnesses, and it threatens public confidence in judicial protection. A county jail sentence sends the wrong message, Your Honor, that retaliation against witnesses is a low-level offense and that court testimony does not carry meaningful protection. The defendant's PRV score is now 105. Level F, the highest category of PRVs. His criminal history spans decades, including multiple prior felonies, numerous misdemeanors, repeated supervision failures, and no 10-year gap sufficient to exclude scoring. While his recent offenses may have been lower level than felonies, they were still violent misdemeanors. He's before the court as a habitual fourth offender, not a first-time defendant who made a poor decision. The court's not sentencing a man who briefly lost his temper, Your Honor. It's sentencing a man who's repeatedly demonstrated disregard for the law. The defense has argued that the defendant has upcoming medical appointments and ongoing medical needs. And respectfully, Your Honor, that argument favors prison, not jail. The Huron County Jail is designed for short-term detention, not long-term medical management. The sheriff's office should not be tasked with coordinating ongoing specialty care or repeated transport or long-term treatment. The Department of Corrections is specifically structured to house offenders with chronic and ongoing medical needs, including in-house medical units, a hospital, continuity of care, centralized management of treatment. It's not whether he will receive care, it is where that care can be responsibly provided. A prison sentence places the defendant where the system is best equipped to meet those needs while protecting the community and the integrity of court orders. Your Honor, although the guideline range remains 10 to 46 months, the harm to the victim and the harm to the justice system in this case is apparent. Those factors justify a sentence toward the higher end of serious, not a county jail disposition. Prison is necessary for punishment, deterrence, protection of witnesses, and reinforcement of court authority. For those reasons, Your Honor, the people respectfully request a prison sentence within the guideline range commensurate with the defendant's habitual court status.
And Mr. Bahani, can you correct me if I'm wrong? I believe his last felony conviction was in 1994. Is that correct? If you know.
Your Honor, I don't have his lien or his PSI, but that does, as far as felonies, that does sound correct.
Okay, because since then, and that's the court's understanding. Thank you, Mr. Bahani. After the court reviewed the pre-sentence report, we have everything from driving while license suspended, traffic offenses, misdemeanor fleeing and eluding, expired plates, again, traffic offenses, not involving alcohol until 93. There was a drunk and disorderly assault, battery. 93 and 94 seem to be.
Your Honor, I apologize. In 2020, there's an assault with intent to do great bodily harm less than murder or by strangulation, as well as a domestic violence.
I don't see that in the pre-sentence.
I may be looking at the wrong one. I am looking at the wrong one. I apologize.
Well, that's okay. There is a domestic violence conviction in 2015. It was reduced to assault and battery.
I say something else, sir.
Well, Mr. Bahani, if you see it, that's fine, but the court records, according to the pre-sentence report, indicate 93 common law obstruction of justice. So that was, he was found not guilty of that. And then from that time, 2005 was the next conviction for no valid license. Domestic violence in 09, aggravated assault in 13, domestic violence in 15, drunk driving, what's assault battery, 11 days in jail with that. In 2024, drunk driving by physically that is impaired driving. And then in this case.
We concur, Your Honor.
Thank you. The court recalls testimony in this case, and if I recall correctly, after the alleged, not alleged, it was proven, after the incident at the bar when the defendant left, there was a point in time the defendant came back. And there was no reason for that, but he did come back. Fortunately, nothing happened, but he did return. And this is witness retaliation, according to the testimony of the witness, who was at the establishment, just minding his own business. Statements were made that were threatening. Defendant denied that in his testimony. And he stated there was a statement about there will be a day of reckoning. The jury determined that that was enough for witness retaliation and found the defendant guilty. Guideline range is 10 to 46 months. And there's no doubt, back in the day, back in the 90s, the defendant was in the court system, a lot for felonies, 3. Misdemeanors have been continuing. That's why the 10-year gap never applied, because there's always something going on in the form of some sort of conviction, whether it be driving while license suspended, domestic violence, assault, battery, whatever it may be. But that kept that 10-year gap open. Defendant is 63 years of age, and I shouldn't say 3 felonies, a total of 5 felonies, 22 misdemeanors. And the defendant is gainfully employed. After looking at this, considering the pre-sentence report and the statement of counsel, will be the sentence of this court. And the guideline range as stated is 10 to 46. Defendant shall serve 300 days in the county jail, credit for 1 day previously served. Crime victims assessment of $130 to be ordered. Court cost of $200, payable at the rate of $30 a month. A fine of $100, payable at the rate of $20 a month. DNA testing, $60 for that, $68 in state costs. And those are due and payable by February 9, 2026. The defendant is to report to the county jail on January 7th at 9 a.m. to begin his sentence. I will allow him regarding treatment. However, you have to report to the jail on time, number 1. Number 2, with nothing in your system, and serve the sentence. I do need to inform you of the right to seek leave to appeal. Pardon me?
Do I get work release?
Just a moment. I do need to inform you of the right to seek leave to appeal. You have absolute right to seek appeal in this matter as well. If you're financially able to provide counsel of your own choice, the court will assign counsel for a public expense. You are to initial the receipt questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 42 days. The court has no objection to PA 511 status or work release, but the defendant must provide proof of that to the sheriff's department pursuant to their policy. If they find he's eligible, the court releases funds. Yes.
I apologize. Did you order attorney fees?
I'm waiting, attorney.
Thank you.
Mr. Grady, just a word of advice. I know you're upset. I get that, but the jury found you guilty. And all I can say is just let it go when it comes to these individuals. Walk away.
I get.
The jury didn't find that, sir.
Oh, well, I told him what I told him. I told him he deserved it. I never told him I was gonna put my hands on him. And if you look back, the only one that was ever violent in this case was Jessica, when she was arrested for assault and domestic violence against me.
Well, Mr. Grady, again,
And this is how they paid me back.
the jury made its decision. The court is honoring that. Good luck to you. Off the record.
Two millenniums before we can catch up. But all right, but I've done this so long that controlled substance cases get disposed of generally, and I just don't understand why there's. Joe Vasquez.
Yes.
That's trial 2.
We're trying to work it out, Judge, but we just haven't.
Okay. And Samiski. Have you talked to your client lately? The last one said they hadn't talked to you for 4 months before the trial, but that's a problem. 2 of them said they hadn't talked to you for 4 months.
I've talked to her, not recently.
When? I mean, aren't you?
Jesus, you know,
Where's Sarah Samiski?
Yeah.
sweet. I hear you. First person here.
I'll be.
This involves the death of the child. That's the injury is death.
Okay.
State is ready.
All right. Okay, and y'all are ready? All right. Y'all been talking? You've been working with him? When was the last time you spoke with him? A month ago, and we're in trial today. My God.
I have been trying to get a hold of his office and then like says they get the phone number and everything. And also I tried to message him and I'm doing very nice.
It's a trial today, yeah, but y'all haven't talked all y'all, I mean, we can go to trial right now and we're ready.
And so on Fridays from 1 to 4, and I've tried to call and I haven't got anything.
That's.
Yes, I did. I was like, not this.
It's the day for trial, you got to strategize and prepare and, rehearse your testimony. You didn't even know you're going to be under office.
I didn't get anything from him. I didn't get any letter or anything.
Well, I'm sorry.
I didn't get anything from my.
That's
Not on Facebook.
that's not. Yeah.
But that's how I had got my whole student shots. That's how I've always gotten hold of it.
She was texting him to Facebook Messenger.
I don't, you know what I'm going to, you know what I would say. I've done this for 40 years and I've never come to a trial without being prepared with a meeting.
I'm ready to try. I'm not.
She hadn't talked.
No one told me anything about the trial.
She says she's surprised there's even a trial today.
The boss was responsible for the people.
You're not? Her lawyer is not?
I do my best.
What have you done? Okay. All right. I've never heard, this is completely, I've done this for 45 years and I've never heard of such, I've never heard of this.
I didn't hear until today.
Really. And then the last, what they said last week when you weren't here at trial docket. So we had a trial docket, you didn't even show up.
I was in those trial.
Sir, you interrupted me just then. Sir, you interrupted me when I was speaking to you. Sir, I'm speaking to you. I didn't finish my sentence, if you'd be so kind. We had a trial docket. You never showed up for the trial docket, and the people there said they hadn't talked to you in 4 months. And it was obvious y'all weren't going to be able to go to trial. We had to go to trial on another case.
Those order from Judge
Sir, once again, those are things you need to speak to me directly for, because the protective orders, look, we know what's going on with protective orders, and this court has a fair opportunity to be heard on its protective orders.
It wasn't a protective order.
Well,
I did pick a jury.
This court generally doesn't do that, but I know some courts do, but I'm supposed to find out way ahead of them. I should know way ahead of the trial when that's being pulled, because the courts have a fair opportunity to be heard, especially ones that don't do the protective orders like I do. I know what goes on, and in some of the counties, it's subject to abuse, and that's not fair to the people who are the 22nd largest county with the 16th highest crime rate like ours. I think we have some prioritization for the people of Jefferson County. You can't go to trial right now. Y'all aren't ready for this.
Trial, but we didn't know when, and that's the first thing I heard.
Okay, well, there's got to be preparation, and you just can't impromptu come up here and start testifying. Just to get rehearsed and things like that. Y'all just be seated, please. Y'all can be seated. Yes, you can be seated.
Okay.
All right. No, what good would it do? It won't do it. There's nothing that really can be done about it. It won't help us. Okay. Then. Okay. I guess. How long would the McCullough case take, do you think? Did you say 3 or 4 days?
Yes, sir. And Mr. Burbank, I think has a sentencing right in the middle of it next door that on that capital case that they pled that the sentencing set for.
What does that mean?
That means he may have to take a couple hours off to go because they've got witnesses coming from different places. So just to give you a heads up.
We'll lose an afternoon.
Sir?
They'll lose an afternoon based upon the time in the month.
Just giving you a heads up, Bill.
On Kenneth Jackson, Mr. Ham on that. I know y'all were in trial all last week. Were you ready for that today? Are y'all ready today on that?
Not to the degree that I would like to be.
I understand.
If it's called, I'll proceed.
Okay.
And we're ready on Patel, Your Honor. That one's not going to be a plea period, from my understanding.
I'm sorry?
We're ready on Patel, the first one. That one's not going to be a plea period.
Okay. Yeah, well, they say they're not, all of them, which is the only court, the only court in the land that's what happens. Only court. But this McCullough on murder, I mean, we got a DWI third and a murder. I think the murder is of higher importance.
If you need to try it, we'll try it.
What do you think? Well, no, where are y'all on that? On that? You're ready. McCullough?
Judge, I've been trying to settle with the state. Well, yeah, he's been talking to me. What's less than a murder though, so I can't give it.
I'm sorry, Mike.
Judge, he's been asking me, he's been begging.
No, he's been trying to work it out with me, but he wants something less, his client wants something less than a murder and I can't go there, so.
Okay, then McCullough first, Patel 2. Then Paul will be 3 and Jackson 4 and Barclay's 5. Okay, that's all we can do. Put those in that orange one document here. So there you go. Thanks. Here we go. Be careful on this.
Yes.
Here.
Isn't that, I might be blind, I think not. Oh, sure. May we be released till 1 o'clock?
Yes. Kelby Green, Langston. Adams.
I'll get that.
Kelby Green.
All right, we got a deal on him. I need to sign it off. That case is going to today. We reached the deal.
What about Christopher King?
That one we sent to you. I had that one with our prosecutor about 2-3 weeks ago. You reset it. You already sent it to you. It's a plea.
Great.
That's sent to you.
Well, you got a couple more. Ashley Moses.
That's going to be with you this morning. And I got for more, it's going, you're going to decide that. Well, we're going to get it. That's going to be finished with your docket today. That's going to just let you decide.
Is that it? I think
that's all 3.
Okay, good.
So I just
tell me when you're ready.
I just need to sign him up. And then the second one, I already sent to you. No, this is Mr. Green.
I'm sorry.
Green, I'm gonna sign up right now.
Okay.
We'll get the second one. I sent
all
me.
of them. Yeah, okay.
Thanks.
Ashton Spearman with Giles. I didn't see Giles. Clemente Hernandez, Mr. Deuce.
You have that one. We're waiting on the interpreter. I may have to be reset if we don't have one.
An interpreter.
Erica's here.
Interpreter's here.
Yeah, Erica's right there.
Oh, I'll need a position of interpreter.
Gotcha. Danny Johnson.
We're ready to go. Go.
What is that?
It's a plea of a motion.
Tori Morgan.
And we're ready on that one as well.
What does that mean?
It's a plea.
Oh,
it's already been signed.
You say
both Johnson and Morgan have been signed up.
And of that, Charles Moss, let me go through this here and see what I'm reading at. Moss has been reset. Ernest Jones reset. Ernest Jones has 4 cases, it looks like.
This should all be worked out at once, Judge.
Given.
I've spoken to Brittany on it. We're just gonna
wait until we can
Okay.
get to court.
Go down and then
All in.
you want to be as well.
Danny Johnson.
It's the person by the front. Your dad and us, what do you mean? Yeah.
Where's Danny? That's you? Okay, let's take care of Mr. Johnson here. Okay. 24 CR 1670. The state of Texas versus Danny R. Johnson Jr. That's you, sir? With you are here with Mr. Dusler, your attorney, and the state's attorney. There's a first amended motion to revoke unadjudicated probation here that we're going to be disposing. Was that your understanding, sir? Please raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth? So help you God. So, all yours. Does the defendant waive a formal reading of this first amended motion to revoke unadjudicated probation? Can we proceed in summary? In summary, this motion in 24 CO 1670, it was handed up. It was filed on 12/3/2025. Okay. Are we ready? Ready?
We have an agreement, yes, sir.
Oh, okay. This was just handed up just a couple of weeks ago. You have a fair amount of time to prepare for any disposition. Are you ready to move forward on this, Mr. Johnson?
Yes, sir.
Do you, and you've talked this thoroughly with your client, with your attorney, you've discussed it. Does the defendant waive any additional time he may have under the law to prepare on and move forward?
Yes, sir. We're ready to go.
All right. And we can proceed in summary.
Yes.
In summary, this first amended motion to revoke unadjudicated probation states that on March 3rd, 2025, in this court, you were placed on 10 years deferred or unadjudicated probation for assault on a peace officer. Is that true, sir?
Yes, sir.
Is it 6?
Sure.
Number 6, in this first amended portion states that you violated your probation by committing the second-degree felony of robbery on or about October 21st, 2025 in Orange County, Texas, which is in violation of condition 1 of your probation order. Is that true? Are you pleading Are you pleading true to this voluntarily and because it is true? Yes. Do you understand that a voluntarily and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment, which is no less than 2, no more than 20 years confinement in prison. Knowing that, do you insist on pleading true today? Yes. I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Yes. The agreement has been reached where your probation would be revoked and you would be sentenced to 3 years. That's what that is, 3?
Yes, sir. I'm sorry, the tablets.
I know. We're going to make the Arabic version. So it's clear. Like a snowman. Okay. 3 years in prison. Is that your understanding of the agreement?
Yes.
If I follow this, you have no right of appeal. Do you understand?
Yes. Yes.
Show you what's marked as States Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney. Is everything true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection admitted. Among other things, this states that you are waiving all rights of appeal if I follow this agreement, which I intended to. All right. Anything else to add? No, I'm going to follow this agreement and I find that there is sufficient evidence supporting this first amended motion to revoke unadjudicated probation. As the defendant has pleaded true to allegation number 6, committing the offense of robbery on or about October 21st, 2025 in Orange County, Texas, which violates condition 1 of your probation order, which is don't commit any offenses while on probation. And that is enough to, by preponderance of the evidence or greater, to grant this motion. Your probation is hereby revoked in this second-degree felony of assault on a peace officer. And I'm going to follow this agreement. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty, all when we placed you on probation in March of this year. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in that hearing to find you guilty beyond a reasonable doubt. Now that your probation is revoked, I hereby find you guilty beyond a reasonable doubt of that second-degree felony. I am following this agreement. You will hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. You will be given credit for all time you have served in accordance with this case. You understand what has happened to those?
Yes, sir.
Anything else?
It's not for a place.
Make that a greater than who is.
Okay.
Right.
Let me interrupt just for a second. Your defendant is. I'm gonna give you all those things.
Yeah, but hasn't happened.
Yes.
Sure, we
Am I
to understand that?
That's correct. We'll call you. But there's 5 ahead of you. Yeah, of her.
Yes, sir.
Yeah.
Your Honor, while I'm here, can we address the issue of removing the ample monitor that you guys had on for
All right.
14 nights now? But anything else anybody else said about it? No violations?
I need the file.
So.
Yeah, and I'm sorry for this taking so long. It's just, you saw what happened. We had not anything but disposed of. And we can only try one at a time. I don't know. I think we're the only one that where this happens like this for some reason in the land. But yeah, on Mr. Woodruff's cases here, I'm sure it's the stalking that had a lot to do with this. Hold on, let me look at something. Just look.
They're interconnected, Your Honor.
Let me just read this real fast. Since first of all,
See, you take this. So this is showing how these things
These two, the defendant and the complainant were married at one time?
Yes, sir. They divorced in 2015, which is the last time they saw each other.
Let me read this. I'll ask you, to tell me what you feel about here in a minute. Let me just.
On Hernandez. I'm just having a chance to speak.
Yeah, get ready to get for All right, where's the defendant? I didn't want to be in the bar.
The device was placed on him, it was October of last year. It's been 14 months. In those 14 months, there have been no violations of any kind. There's been no contact with some plan. In fact, they haven't seen each other in over 10 years since the divorce in 2015. My client doesn't even know where she lives. There have been no prior offenses involving any kind of violence whatsoever in his history. And also there's the cost of the device, which is taking still on my client since these charges caused him to lose his prior job, and he's had difficulty making ends meet since then. But he is doing it, but just the cost of the device is taking its toll. And I believe mitigating all of these, the device being placed on him, all these factors that I just told to the court, Your Honor. He's here, he's come to all of the court settings. He has no intentions of making any kind of contact with my client, especially since these charges were placed on him. And we would ask the court to consider removing the device placed on these factors.
Your Honor, given the nature of these charges, and speaking with the victim in this case, we do believe that there is a risk of contact. I think that this is a safeguard against that. He knows that he's being monitored right now, so he hasn't had any contact, and we would like to continue to prevent contact until this case can be resolved once and for all. So we'd ask that it remain on.
And for that, I would just offer that I don't think the defendant is going to risk the consequences of such contact, given the defendant's familiarity with this court and the possible consequences that would ensue if any contact should be made. I think the court can rest assured that the complainant need not worry about any contact being made by the defendant.
Well, I'm looking at this probable cause affidavit, and it's disturbing to say the least. Each act was a crime. Each act is a crime. They only indicted you once for one. But each act is a crime of what I'm reading about, these threats. And does the defendant have a criminal history at all, any at all?
He does, Your Honor, but they're from, none of them are any offenses involving violence, and the ones that he does have are like from 20 years ago.
I don't believe there's any felony history, Your Honor.
Okay. These, I'm looking at one set of messages here on January 3rd.
Yeah,
let me just, it's not a debate. I'm reading this and it's what it is. These are very, you would have to agree, these are most disturbing.
If they were
disturbing. Okay.
Yes, sir.
Okay. All right. If they were true.
There is a
There's voice. There's, do y'all have voicemails on this? Recorders voicemails? There, it says, sent 2 emails with 2 voicemails. And the first voicemail said one thing, and I mean, these were, then the officers received additional emails from the complainant with screenshots of missed calls and a text that was sent to the complainant's son, which was a picture of an insurance policy. Do you have that?
Yes, we have that.
Okay. Okay. All right. And these emails, screenshots. And Officer Avery received an email from the son of the complainant that he received nude photo of his mother via text message for the second time. I mean, this was a period of time where heck was occurring. This was very threatening and intimidating. It hasn't occurred since.
To my knowledge, no, Your Honor,
I
but
think it's because of what she came forward and had the courage to make a complaint, and that the conditions of bond that was set or freezing this action. But this is not just one isolated event. This was several things that happened.
that are alleged to have happened, Your Honor. And I would say
The message is, come on, y'all have text messages?
But Your Honor, the text message.
I'm sorry. Y'all have text messages?
yes, we have all of the evidence that we got from the police department.
All right. So you're saying those are contrived and made up?
No, I'm just saying there's.
You're nodding and he's saying no. Y'all need to get on the same page. Here's what we're going to message. The condition of bond continues. We're freezing this and this situation until we can get this thing to trial. But I've done this so long, I know what happens. Passion plays in all romantic interest. There's passion in it, and it makes people, it can cause people to act sometimes in a way that's unreasonable to what they normally act like. But what we're going to do is shame on somebody. The first time, shame on me. The second time, on my watch. If I let the guard down. Right now, there's nothing bad happening that I'm aware of.
That's correct.
So we're going to continue the status quo until we can get this thing disposed of and try to get it as fast as I can. I've tried 600 jury trials. I'm going to brag about it because I don't understand 600, and that doesn't stop people from asking for trials here. You would think people would say, "Oh, he's going to try this case." We all know 98% get disposed of without a trial. For some reason, 98% go to trial here, and I can only try one at a time. But when you find a judge that's tried 600, let me know. Felony trials, let me know, because this doesn't happen. we're working one at a time as hard as we can. And one of the reasons we don't have additional problems while on bond is the court's bond is firm about the bonds. And he's going to have to kind of bear with this a little longer until we can get this disposed of. But nothing bad is happening according to the state. And the court feels like the bond condition on his device is able, and it is in not his case, but in almost all cases, stops issues and keeps the status quo from changing for the worse while we're waiting. And that's, I appreciate your vigorous representation of him, but this is in the best interest of all concerned. And that's my good point. What are we going to do on this?
The state is ready for trial. We are ready today, Your Honor. It's just a matter of getting it on a trial docket and reaching it.
Get it to trial as soon as we can. Yes, you felt it in your phone. So
Thank you.
get it reset. The stalking case is what we're going to try first.
No, it's the other one, Judge.
I get to decide, don't I?
Yes, you do, Your Honor.
That's the one. Yeah. Y'all ready? Okay. Come on up, Langston.
Your Honor, up until now, I have been preparing for the trial.
This is the court's rules.
Yes.
We're going to go on the 30-degree felony. Thank you. All right. What do we have?
That's Mr. Green.
Okay.
I'm sorry. Fingal coaches.
Mr. Green, please raise your right hand.
Yes, sir. And we said the paperwork was.
Yes, sir.
That's Green. And then I got.
If you gotta do the whole.
Pain, it's another plea. I said that too.
Was it on the trial?
Sorry.
Because these are trial.
No, this is the other, it's the first that you called, you know.
Okay, do you have Greens? I think these are the trial. Is this the trial?
No, that's, you've got it. I have all the trial documents.
Okay. I thought that one with, dang.
Which one?
It's just one case?
It's a one case. It's an MTRP.
Face nothing?
MTRP.
Just like it sounds. All right. We now call cause number 23-41394, the state of Texas versus Kelby Green. That's you. Present with Mr. Adams, your attorney in the state's attorney. There is a second amended motion to revoke unadjudicated probation that's pending. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes.
In summary, sir, and raise your right hand. Do you solemnly swear or affirm any statements you make will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
In summary, this motion states that on July 31st, 2023, in this court, you were placed on 10 years deferred or unadjudicated probation for the first degree felony of aggravated assault. Was all of that true, sir?
Yes, sir.
Which one is it pleading to? Yeah. We've got failing to report.
Yes, sir.
Number one states violation, you failed to report to the Jefferson County Probation Office on or about December 13th, 2023, January 10th, 2024, January 29th, 2024. Did he become an absconder? No, he just missed those dates. Okay. What happened on those? Why didn't you show up on those?
Remember I told you I got shot?
I'm sorry?
Somebody explained to you later, somebody got shot.
Yeah. I've got 5,000 defendants here. You're familiar. I just don't remember that conversation. Tell me again if it happened.
I got shot in July.
And then you went to the hospital?
Yes, sir.
Okay. So you weren't able to report because you were in the hospital?
I couldn't even walk.
Okay. Well, we're not going to get him on that. I mean, if he couldn't make it physically, then we're going to have to do something else. I'm not going to revoke him for that.
No, but he has a like.
All right, let's go to
14
something.
violations.
Well, give me another one. What's this number 12?
I think
Committed the offense of illegal possession of a controlled substance in September 25.
Yeah, that's not fault. Yeah, but what I was looking at, Judge, is
Whose court is it in?
I think that would be in drug court. But he had tested positive for marijuana on 2 separate occasions. In June 24th, tested positive for marijuana. And then he also tested positive on September 4th.
Yeah.
And he also didn't do that.
Okay, hold on. Number 8. This states he provided a urine sample on June 24th, 2025, which showed the presence of tetrahydrocannabinol or marijuana in the system in violation of his probation order. Is that true? Are you pleading true to that voluntarily because it is true as it is alleged?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true to 1 or more violations of probation, that is enough to grant a motion to revoke probation? Your probation can be revoked. You can now be found guilty and sentenced up to the full range of punishment. This is a first-degree felony, no less than 5 no more than 99 years confinement in prison or life imprisonment. Knowing that, do you insist on pleading true today? Yes, sir. I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. All right, so let's see where it goes. An agreement's been reached where your probation would be revoked. You would be found guilty of this aggravated assault and sentenced to 5 years in prison. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you what's marked. States Exhibit 1 here. You just sign that document voluntarily, understand it, discuss it with your attorney.
Yes, sir.
Or the contents are true and correct.
Yes, sir.
States Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's submitted. Among other things, this states you were giving us all rights of appeal if I follow this agreement, which I intend to do.
Yes, sir.
Anything else to add? Then I will find that you have pleaded true voluntarily to allegation 8 of the first amended portion of this second amended motion to revoke unadjudicated probation in this cause number 23-41394 case. You were mentally competent to do so. This was voluntarily and knowingly made. It is enough to grant the motion to revoke probation by preponderance of the evidence or greater. I so find that to be done. Your deferred or unadjudicated probation is hereby revoked for that violation of probation. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood that consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt.
Yes.
In this case, I am following this agreement. You were hereby sentenced to confinement for this first-degree felony of aggravated assault, confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. There will be an affirmative finding that a deadly weapon was used or exhibited in the commission of this offense, namely a knife. Do you understand what has happened today?
Yes, sir.
Anything else to add on this? Nothing from the state. If not, that is all. Thanks.
Yeah, they will be there on Thursday. Thank you, Judge. Two more.
Who's next?
Mr. Kane. And he's ready. We sent that too.
And that was, once again, that was Kelvin, right? Just Lynn Green.
Yes, sir.
Okay. Who is it?
Mr. Kane.
Christopher Kane. They said he was 23 CR 391.
Yeah, he's coming. We sent down.
I don't have the paperwork just yet from stage.
Hey.
Christopher Kane, who's got that one?
I sent it like.
Was it on a different date?
Yes.
What date is it under?
She sent it on, I think that was, what day we was in for about a week ago? I know I signed it, everybody signed it. It was the last quarter.
Thank you.
All right, you were Christopher Kane?
I'll just swear in a fingerprint.
You need to go in front of that lady, she'll swear you in.
And Judge is gonna be under 12-5. The paperwork is needed. Mr. Kane, you can swear what her. It's right fingerprint. It's flat right there on the box. Right, so it's flat right here. You just need to judge.
23 CR 391 is now called the state of Texas versus Christopher Kane. That's you. Is he present with your attorney, Mr. Adams, and the state's attorney? Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed? So,
yes, sir.
In summary, this indictment alleges that on or about April 8th, 2023 in Jefferson County, Texas, you committed a second-degree felony of sexual assault involving a child younger than 17 years of age. You understand what you were charged with? So, if convicted of a second-degree felony, you were facing a term of not more than 20 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand what second-degree felony punishment can bring forth under the law in its punishment?
Yes, sir.
An agreement has been reached in your case where you would be pleading guilty, sentenced to 10 years in prison. And that would run with concurrently with other cases. Is that your understanding?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge? Guilty or not?
Guilty.
Are you pleading guilty voluntarily? That is, on your own free will, and because you are guilty?
Yes, sir.
I'll show you what's called the State's Exhibit 1 here. Did you sign this document, understand it, discuss it with your attorney, or the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read for you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true state, so help you guys. Yes, sir. State's Exhibit 1. part of the record for all purposes without objection. Present his report as waived here.
Yes, sir.
I will follow this agreement, sir, and I'm going to find you are pleading guilty today voluntarily to the second degree felony of sexual assault involving a child. You were mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt from State's Exhibit 1 admitted here. I now find you guilty beyond a reasonable doubt of this second degree felony. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. You will be given credit for all time you have served in accordance with this case. Do you understand what has happened today, sir? Yes, sir. There is an affirmative requirement here in all cases involving crimes such as this. You are required to register under the Texas Sex Offender Registration Law Program. Do you understand that? Yes, sir. I'm going to show you here what is called the Sex Offender Registration Admonishments, Chapter 62, Texas Code of Criminal Procedure. And so this is, this is what filled in the date. Part needs to be filled in, and I can do this for y'all. Okay. Did you sign that document, understand it, and discuss its contents? It's all of the communication in that with your attorney. Yes. Okay. Stay behind. He has affirmatively acknowledged this, and this is your signature at the bottom. Yes, sir. This states that you acknowledge that you've been admonished by your attorney that one, you have a reportable conviction now or adjudication requiring you to comply with Chapter 62 of the Texas Code of Criminal Procedure, which is the Sex Offender Registration Program. Failing to do so is a criminal offense that can result in prosecution of you. Do you understand? Yes. If you move to another state that has similar reporting requirements for sex offenders, you must register in that state as well. Failure to register can result in you being charged with a criminal offense for that matter. Do you understand? Yes. And this will be made a part of the record here for all purposes. Anything else to add on this list?
Nothing.
All right. I think that should do it. Yes, that's all. Here's this. I've got Corey Morgan.
I'm ready on that. So I got this. I got one more.
Who is it?
One more left. I got Mrs. Ashley Molo. That's the last one I got.
Ashley who?
Molo.
Okay, I don't have that at all here, but Ashley Molo, where is she? In custody?
Yeah, she's. No, that's gonna be before you. It's an MTRP, and she's gonna plead truth to them. So we're gonna just.
Okay.
Right. So that's gonna we're gonna move that to that.
Ashley Molo. Well, she's got 2 files here.
Right, it's 2 cases. One is a state jail and one is a third degree.
Oh,
so we're gonna move.
She's on probation in both?
On probation in both.
And there's motions to revoke probation in each one?
Yes, sir.
Okay.
So we're gonna expose to that now.
All right.
That is like Thank you.
Two cases are now called 23 CR 1236 and 23 CR 1385, the state of Texas versus Ashley Washington Molo. Is that you, ma'am?
Yes, sir.
Present with Mr. Adams, your attorney, and the state's attorneys. There are two motions there's a motion to revoke unadjudicated probation in each case. Do you understand?
Yes, sir.
We are ready to proceed today on this to dispose.
Yes, sir.
Please raise your right hand, ma'am. Ms. Molo, do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Thank you. Does the defendant waive formal readings of these motions? Can we proceed in summary?
Yes, sir.
Motion number 23 CR 1236. The motion to revoke unadjudicated probation filed on August 19th of 2024 in that case states in summary that on November 6th, 2023, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of theft. Is that true?
Yes, sir.
And I'm going to jump over real quickly and hold that one in advance. Go to 23 CR 1385. And this is a motion to revoke unadjudicated probation, also filed on August 19th, 2024. And in summary, this alleges that also on November 6th, 2023, in this court, you were placed on 10 years deferred or unadjudicated probation in that case for the third-degree felony of continuous family violence. Is all of that true and correct?
Yes, sir.
Allegation 1 in each case states that you failed to report to the Jefferson County Probation Office for the months of May, June, and July 2024. Was she an absconder and did she?
Yes.
For how long? Is that true and correct?
Yes.
You failed on that, but you were gone for a while here.
Yes, sir.
We didn't see her on May 24.
Probably until she got arrested.
Until she got arrested when? What was her date of arrest, please?
October 6th of this year.
Of this year? Okay. October of this year. So we've got about almost a year and a half.
Yes.
All but didn't know yes. Are you pleading true to allegation 1 in each of these cases of these allegations of failure to report and absconding from the Jefferson County Probation Office? Are you pleading true voluntarily? And because those allegations are true in each case?
Yes, sir.
You understand that knowing and voluntarily made plea of truth to one or more violations of probation, that is enough to grant a motion to revoke probation.
Yes.
Your probation can be revoked. You can be found guilty up to the full range of punishment in cause number 1236. 1236. This is a state jail felony, though it's on a standby. Let me see. State jail felony. And you are looking at no less than 180 days up to 2 years in the state jail in that case. And in the third-degree felony of continuous family violence in 1385, you are looking at no less. You were placed on deferred or unadjudicated probation in each of those cases. You can now be found guilty in each case and sentenced in this third-degree felony to no less than 2 nor more than 10 years confinement in prison. Do you understand?
Yes, sir.
Knowing that, do you insist on pleading true today in each of these cases?
Yes, sir.
I find you pleading true voluntarily. You understand and appreciate the consequences of pleading true. There are no agreements here?
Yes, no, sir. We're going to you right there.
Okay.
And I'll tell you, Judge, the
Here we
reason,
go. First,
Judge, the reason why I'm asking you to continue her on supervision and if not, change the deferred to straight probation and not any kind of pen or jail time. The offer was 1 year on the state jail and 3 years on the felony case. The reason why I'm asking you.
Originally?
No.
He's referencing the deal I made offered today.
Correct.
Okay.
Judge, the reason why I'm asking you to keep her on probation is twofold, Judge. If you look at the time where she did not report, and I think I'm looking specifically on page 2, and that's paragraph 1, where she didn't report in May, June, and July of 2024, and that's on the second page.
I know, but
I was going to tell you
that continued.
Yes.
In August, September, October, November, December, then January, February, March, April, May, and when was she arrested?
October of 2020.
June, July, August, September. Okay.
Right. And I
almost lost all my breath there by saying all those months. Okay.
Right. Something traumatically happened that summer, and I was going to tell you what that was, Judge. When I talked to her, and to the right, to the back, is her boyfriend and then her grandfather, and they're here for support, and I can call them to talk to you, confirm some of this as well. Something traumatic happened to her that summer. She went to the ER and she found out that she had a mass that they believe was cancerous. She didn't have any insurance. She didn't have any Medicaid, Judge, and she went into a very, very deep depression. She did eventually get Medicaid and insurance. And while she was out, she did go to the doctor, and you can confirm, I think the doctor name is Dr. Amber Teal with UTMB. And it's to my understanding that as of this December the 18th, she has an appointment with that doctor. They're going to do a biopsy on the 18th at UTMB. I know part of the allegations was failure to work. She did establish a job at Cracker Barrel. She also, one of the allegations was doing the mental health assessment. She did, in fact, go to MHM.
She's pleaded true to just one allegation. That's all she's pleaded true to.
Right.
But it's the most important thing. If you don't show up for work, you get fired. You got to show up, no matter what it is, no matter what the situation, you got to show up. And we can accommodate issues. We do it every day with all the probationers, staff, something. But you have to do your part. If you don't show up and report, you're not on probation. You're not on my supervision. You're on your supervision, which is backwards, and we can't have that work that way. The law says the court is the supervising official, not the defendant of their own probation. And this happens from time to time.
And Judge, the reason why I was asking you not to send her to the prison is that, and even with the underlying offense, it was an issue with her and the boyfriend. And to my understanding, there's no problems with her and the boyfriend, even while they were out now. And I think that factored into why Mr. Ham offered a deferred adjudication initially in this case. So she's not going to be a danger to herself or anybody else. At the end of the day, Judge, what you got here is a woman who is probably going to have some serious medical interventions. And that's why I had brought her grandfather and her boyfriend here today to establish that, as well as give you the name of the doctor so you can actually confirm yourself with a Dr. Amber Teal.
No, I'm not going to do that.
No,
that's y'all's obligation.
No, I'll provide that information. And what I was saying, Judge, is that the reason that she did that abscond and she was gone so long is that she went into a deep depression. And I think during the time that she's been locked up since October, we're now in December, she got her head together. And I think, Judge, with the support that she has in the back, and I pointed out the two individuals in the back, she has a place to stay. To my understanding, she will be allowed to go back to Cracker Barrel where you work, right? They'll take you back to work. And as far as paying any fees or if there's any kind of restitution on it there, she'll be able to do that. But the reason why that we did not take the 1 year and a 3 year offer that was given to us is that Judge, she has cancer and she has, well, I'm not gonna say that. God, hopefully she doesn't, but she does have that biopsy that's set on the 18th. And I'm hoping that it works out well, but I'm just asking.
Hold on for a second. Biopsy on the 18th for what?
Well, she had the mass on her breast, and I think Dr. Teal at UTMB, or you can speak for yourself.
Had been living the same for a couple months.
Right. So she's set to go to the doctor on the 18th in Beaumont at UTMB Beaumont.
As far as the depression, I'm signed up with MA tomorrow. They have me on anxiety medicine and the depression medicine, and mentally I'm doing a whole lot better.
Well, we can do the math here.
Mm-hmm.
She just learned about her situation a few months ago. She's been gone for a year and a half.
For longer than that. I just
When did the doctor determine that you had serious illness? When? What was the date?
Like in July
Of what?
this year.
I know that was you had been gone a year.
Yeah, I found
You
out
had been
about it
absconded for a year, ma'am. Okay. It's not like you found out and then you, oh my God, we got to go to an island and reflect on this somewhere.
Well, I found
You didn't know what your condition was for a year into your absconding, right? You had been gone a year. You just quit on the job and walked off. And you didn't know. That wasn't a reason that you were sick. You just, for whatever reason, you got to report. You got to come to work or else you don't get paid. You got to report or you're not being supervised. The fact that you ultimately, after a year, understood that you had a medical condition, that doesn't purge the fact that you walked off the job for a year and you didn't have a diagnosis at that time. You made the decision to leave, but it's the same thing. I treat people the same way. That's the most important condition, or else you're not on probation. You gotta, there are so many conditions and we relax 95% of the conditions, but the one that has to be done, that has to be performed is you got to report.
Yes, sir.
And when you walked off the job for a year and a half, that I can't open the door for, okay, that's okay. I'm going to make an exception in this case because we have 5,000 probationers. They'd all go, I would like the Ashley Molo rule. She got to take a year off before it was understood that she had a medical condition, but she decided for whatever reason not to report. And then we just put her back on probation. That's not the way it works. And you got to report. But the court is not going to, it's not going to be harsh with you. I'm going to be fair. Anything else?
That's the main ones I was going to.
Okay,
she can speak to them. Well, I'm sorry.
By my estimation, that 20 months amounts to on average 30 days. Those months, that means for 600 days, she decided not to do anything. And I love the excuse that's given. Primarily, I say it that way because the nature of that explanation means that every day she had to have been impacted by that. And by the nature of its explanation, that's not how that situation works. So that means that for 600 days, she decided she didn't care that the state offered her probation and gave her an opportunity to show she wanted to do right. Instead, as the PSI you look at, when she's been given probation before, each time it's been revoked. I went on, gave her another opportunity, gave her a chance to try to address the violent nature of the felony third degree that she's got. She didn't do that. And she just was thumbing her nose. There's no reason to give her the leniency they're seeking, Judge.
All right, anything else?
Don't say something yourself, please.
Yes, sir.
Go ahead.
I know I was on probation and I should have taken it more seriously. I apologize for that. I'm on my medication now. I'm mentally, I'm okay. I'm able to work. I'm able to go to any classes you need me to go to, counseling, anything that I need to do to get another chance so I can be able to take care of myself and my health.
All right. You're being straightforward with me.
Yes, sir.
How many convictions do you have?
I'm not sure.
What does that say?
Right.
What does that say of someone? That you've got so many convictions, 9 that I'm counting. You have so many you can't even remember. And you're intimately familiar with your own life. Most of these are thefts, crimes of dishonesty, which unfortunately follow you around when you attempt to make a statement. And I can tell you when, and the way the law works, when you make a statement in a court proceeding and someone has a counter statement that refutes that, the person who doesn't have the 9 convictions of theft is going to be more believed than the person who does, because the way the law goes to credibility. And the concern I have is I don't see any physician state, I don't see any medical proof other than a word to you that she's got a condition that she states. And how can I believe her when she had 9 convictions?
Judge, if it will help, I have Mr. Edwards and the grandfather, Mr. Smith.
I want to see a doctor's diagnosis in writing. That's all we can do. That's all we can really rely on in light of, the issues here.
Well, the biopsy is going to be scheduled for the 18th. So I think that's going to make.
See, all of this, we don't even know. You don't even know really what her condition is, but it's been portrayed as though it's something and it may be, but we don't know for sure. But it's portrayed that this was something that was understood long ago, and that's not true. That's not the fact. That's not factual. She absconded for 1.5 years, and she still doesn't know what her exact diagnosis is. So she can't really use that as an excuse. She certainly can't use it as an excuse because she didn't even seek the medical attention after 1 year of absconding. And that's where the problem is, along with her rich criminal history. What's the state asking for?
And Judge, when I extended the offer that Mr. Adams has mentioned twice on the record, I was not aware that she had been absconded for 20 months. My goal at that stage was to try to address what I saw as just a disregard for the probation. But when you consider it 20 months at this stage, I think probably she needs to be revoked. I would suggest 4 years and 15 months state jail.
Mr. Adams, on behalf of your client, what are you asking for?
Judge, I was asking, since she's on deferred adjudication, if the court was not amenable to keep her on deferred, then you can always change that to straight probation instead of deferred. And that would be a sanction because she would lose the deferred. And then at the same time, she better keep that appointment coming on the 18th for the biopsy. And like I said, I brought the 2 gentlemen there just as the support to show that they would be willing to get her to her doctor's appointments, get her to the most important thing, which is the probation, that she would have transportation, she would have a house to live under, and that's why they're here today, that they'll provide that. And
if she is incarcerated, the jail is going to make provisions to make sure she goes to necessary medical needs. They're not going to just let her sit in jail and let that languish. They have a responsibility to make sure that she goes to those situations. But let's just say she's not placed on probation due to the circumstances of this case, and rich criminal history. What are you asking?
Um,
The minimum.
yes, and yes, I'll be asking them.
Okay. You were looking at in each case, ma'am, of no less than 180 days up to 2 years in a state jail felony, and no less than 2, nor more than, was it the second degree felony?
Third degree,
Third degree, and no less than 2, no more than 10 years confinement. In the third degree felony, do you understand?
Yes, sir.
Anything else to add?
No,
By anybody? Okay, in each of these cases, I'm going to find that there is sufficient evidence supporting the motions to revoke unadjudicated probation, to grant them by a preponderance of the evidence or greater, as allegation 1 is proven true in each case. You failed to report and absconded from probation for approximately a year and a half. That is enough to grant these motions to revoke probation by preponderance of the evidence or greater. Thus, your probations and your deferred or unadjudicated probations in each case are revoked. In each of these cases, you have pleaded guilty voluntarily earlier. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in each case to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. Stand by on that case. Is there restitution on this? No restitution.
I didn't see that. I believe they recovered all items, Judge.
And there is enough evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in each of these cases. And in this state jail felony, you were hereby sentenced to confinement in the state jail for 180 days. In the third degree felony, you were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years. These sentences shall run concurrently. These are the minimum in each case, even though the state's requests are reasonable. I find under all of these circumstances that probation, it just is not realistic under these circumstances. But the court finds that the minimum sentences in each of these are appropriate based upon these sentences and the Christmas season. Anything else? That is all. Langston, what did you have next?
That's it, Judge. I'm good.
Okay.
I'm good. Thank you, Judge.
Yes, sir. I have a Clemente Hernandez.
I'm ready, Judge.
Come on out.
Mr. Hernandez, please.
I'll need this for him. You know, kind of. You do a discovery, sir?
Let's see that.
They speak English.
She said,
We have an interpreter.
yes, sir.
What's he gonna do? What are we doing?
5 years TDC.
That's correct, Your Honor.
Just paragraph 1.
Yes.
Component.
Can we just step in front of me, please?
And Because the defendant is not fluent in English, the court, the interpreter today, hold on. The interpreter is provided. Please tell us your full name for the record.
Erica Burge.
Ms. Burgess, interpreted numerous times in this court. Do you solemnly swear or affirm you will interpret into the language that the defendant understands, which is Spanish, all of the English that is stated during this hearing, and you will translate the Spanish to English, English to Spanish as necessary? Do that correctly, so help you God.
Yes.
Lower your hand. No problem. Go ahead.
Señor, pasa para acá.
For her. Give it to her.
Se lo voy a dar, pero primero tenemos que tomar sus huellas. No, tiene que poner sus huellas primero.
Do you know what he's talking? Do you accept that? First of all,
I hand these to you before he does the fingerprint.
those have to go to the attorney. It has to go through his attorney. And his attorney decides whether it should come to me. You can't speak directly to me when you have a lawyer. It's the rules.
Esas son las reglas. Vamos a tomar sus huellas.
Talk to him for a second.
Is it in Spanish?
No, it's in English, but it's like some handmade motions. We're not going to present these.
No, hecho more.
Hold on. Tell him, this case was supposed to be disposed of today. You were going to be entering into a guilty plea on an agreement. Is that true or not?
Yes.
All right, that's what we're going to do. Thank you.
You swear or affirm? Yes. You have your right imprint?
Pro se motions for an
You got one more time? Una vez más.
They're all practicing law in the chamber without going through their lawyer. Okay, 25 CR 1122 is now called the State of Texas versus Clemente Castro Hernandez. That is you?
This is usted.
Yes. She has to take it, she has to take everything down and it has to be spoken out loud. Thank you. Okay. Does the defendant, who's here with his attorney, Mr. Dusler, waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes, sir.
Mr. Hernandez, in summary, and we're only in paragraph 1.
That's correct.
In summary, this indictment states that on or about June 23rd, 2025, in Jefferson County, Texas, what do you say?
He says he understands.
No, this has to be done by the law. So bear with us, okay? This states that on or about June 23rd, 2025, in Jefferson County, Texas, you committed the 3rd-degree felony of obstruction or retaliation. Do you understand what you're charged with?
Yeah. Yes.
This is a 3rd-degree felony, which means if convicted, you face a term of not more than 10 years or less than 2 years in prison.
Sir, last question, no. He lied to me.
I'm sorry.
You said that felony.
Listen to everything at the end. You're interrupting. This is the law. It's all going to keep working out. Just listen to it. And if there's a problem at the end, let me know. All right. For anyone charged with a 3rd-degree felony, you are facing no less than 2 nor more than 10 years confinement in prison and fine up to $10,000. Do you understand what you could be facing for anyone charged with a 3rd-degree felony? Do you understand? Okay.
Entiende, sí o no?
See?
Yes.
All right. hold on. An agreement has been reached by the parties, the state and you and your lawyer, where you would be pleading guilty, sentenced to 5 years in prison. Is that your understanding of the agreement?
I say something.
No, yes,
He
what?
lied to me. He told me his second degree felony.
Yeah, okay.
I think where he's going with it is if the court went forward against it,
Yeah.
20 years.
All right, listen. Okay. This is the crime in paragraph 1. And he made an agreement that the state would not go on this as well. This is a prior robbery in 2020 that was committed and that was disposed of in the court next door. If he did not ask her and the state decided not to move on this, they could have added this, which would have meant it would be a second degree felony. You were looking at up to 20 years in prison. They could do that, but he said, he talked her into not doing that and reducing it to a 5-year sentence. Do you understand? If you went to trial, this and this would both be brought in and you would be looking at up to 20 years in prison because this prior conviction moves this punishment one level from a 3rd degree to a 2nd degree under law. Do you understand? Okay. But we're not going to do it that way. We're going to just stay with the 3rd degree felony, the agreement that they both worked out for you. You're looking at 5 years in prison. Is that your understanding of the plan?
So
Because you're not eligible for probation because of this prior. Don't interrupt. Wait. Only one of us can speak at a time. The court reporter has to take everything down. This lady, when we both speak over each other, she can't do her job. And she is the most important person here because everything has to be recorded if we want to appeal something. So you understand the plan of 5 years in prison and only paragraph 1. Right. If I follow this agreement, which I intend to do, you have no right of appeal of your case. Do you understand?
Yes.
How do you plead to this 3rd degree felony of obstruction or retaliation, guilty or not guilty? Are you pleading guilty voluntarily? And because you are guilty of what the indictment states?
Yes, sir.
Okay. I show you what's marked as State's Exhibit 1. Did you sign that document? Understand it, discuss it with Mr. Dusler. Is everything true and correct here?
Yes.
State's Exhibit 1 tendered into without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of this crime and any lesser included offenses. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Is the pre-sentence report waived here? I am going to follow this agreement, Mr. Hernandez. I'm going to find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this first paragraph here, 3rd degree felony of obstruction or retaliation. I now find you guilty beyond a reasonable doubt of that crime. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years. Do you understand what has happened today?
Yeah.
Yes.
Anything else from the defense? Stay.
No, Your Honor.
All right, we are in recess. Hasta luego.
I've got one other, please.
Who is it?
Corey Morgan.
Tory Morgan, please.
It's not.
Nothing was ever supposed to be easy in this room. And it's proving true. I read that somewhere. Believe it. It's the manual. Let's see where we are on this one.
This is a count, please, so this have to reset the page. So
10.
Yes.
That's 10 years.
Yeah. Sure.
Morning.
In front of that lady first, please. Thank you, ma'am. Thank you.
Now.
You can right hand, you swear or merge over here. Just or stuff you got, yes. You can go right hand check. You're gonna place it flat right there on the bottom. You get that one more time. So they're flat right there.
We're checking. This is not a registration offense.
25 CR 1513 is now called. The state of Texas versus Tory Morgan. Is that you, ma'am?
Yes, please.
You're here with Mr. Dusler, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, sure.
In summary, this indictment alleges that on or about March 16th, 2025 in Jefferson County, Texas, you committed the first degree felony of promotion of prostitution involving a person younger than 18 years of age. Do you understand what you are charged with here under section 43.03 subpart B subpart 2?
Yes, ma'am.
That's under Texas Penal Law?
Yes, sir.
If convicted, you are facing a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable here?
Yes, sir.
An agreement has been reached where you would be pleading guilty, whatever sentence shall not exceed a cap of 10 years in prison. So we're looking at no less than 5, no more than 10 years confined in prison. I guess you could be placed on deferred or probation. Also, I don't know what the law states that there's a limit where she could be placed on regular probation. She could be sentenced to no less than 5, no more than 10 years confinement in prison. That could be suspended and then you could be placed on regular probation. So there are 3 options here. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
I show you what's marked as States Exhibit 1. Did you sign that document voluntarily, understand it, discuss it with your attorney, or the contents officer incorrect?
Yes.
States Exhibit 1 tendered into evidence without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offense. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true, so help you God. States Exhibit 1, part of the record for all purposes. Okay, we're going to need a pre-sentence report. That's what we're going to, the probation office is going to come talk to you and do a report. We are going to come back at that time. Anyone, any side who wants to add additional information can do so. And we're going to reset this for a sentencing hearing on
January 26th.
January 26th of the new year, 2026. You understand where we are on this? Probation office, when they come to talk to you, please cooperate with them so that we can get a full understanding of your perception of all of this and your thoughts and feelings. And also at the hearing, you'll be able to add anything else to your lawyer, and the state will also add any additional information. Okay, you understand what's happened? Let's reset.
Yeah.
Yes, you're approaching Ashton Spear. How does that really sit, Judge?
Yeah, who is it?
Ashton Spear. Yes, in TRP.
Where is he?
He's in the back of it.
Okay.
Sure.
You have a motion filed originally in May, and then now it was amended to add 2 additional allegations. When are we going to have a hearing on this? Who's the lawyer on this one?
I am good. Like, let's not follow that thing when obviously
How much time do you need?
Thursday, I'll also on that one.
Okay. All right, we're going to reset this 4 weeks.
Yes, sir.
Okay.
Thank you, Judge.
Yes, sir. Yeah.
I'll say all motions.
It's 2 cases. Navalis? Raul Navalis? Is that yours, Ricky? No, how was that now?
Lagging a little bit.
Judge, she's a plea.
So let me just tell you. You can't get up and soar with the eagles when you stay up all night hooting with the owls.
Well, that you are right there, Judge. Holidays are.
Doing a little owl hooting last night, were we?
No, probably for your Christmas gift.
Just work, just work.
Raul,
Yeah.
you cut a sweetheart deal on this one, little girl.
Am I
Christmas
And that's exactly what she told me, Judge.
That is
He
one of
was
the first
doing a
things that I
sweetheart
asked more is, are you in the Christmas spirit?
She wore her green today to make sure I was in the Christmas spirit.
Humbug. Humbug.
Well played, well played.
Well, I struggled through decorating the tree last night. It's always one light that ruins it all. One light bulb. That just infects the whole tree. Okay, in front of that lady, sir. Thank you.
You swear or affirm?
Yes. He's speaking English, so
Yes.
I was lazy about putting up my tree. My daughter's, she'll be 11 Friday. But I was taking a nap and then she came, woke me, well, when I woke up,
and she did it for you.
she came and got me. I was like, Mom, can you come look at this for me? And then I go in there and I have a whole Christmas tree.
Well, I was shopping extra for her yesterday. 25 CR 1241 is called Raul Navajas the third. Is that you?
Yes, sir.
Present with Ms. Minaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
Yes.
In summary, sir, this indictment alleges that on or about June 6th, 2025 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you are charged with here in the indictment?
Yes. Yes, sir.
All right. There is an agreement that has been reached that you would be pleading to the lesser included Class A misdemeanor of what?
Just normal evading on foot.
Okay. Under, I'm going to put all this down. But where is it? In the peanut butter.
Is it 38?
$38. Is that between 37 and 39?
Yes, sir. 3804.
Evading arrest or detention. All right, person commits an offense if he intentionally flees from a person who knows is a peace officer, which is what is alleged, attempting lawfully to arrest or detain him, which is what this alleges. And this offense is a Class A misdemeanor, except it is a third-degree felony if he uses a motor vehicle. So we're taking the vehicle out, essentially, and
Daniel's gonna find a confession.
not writing it, I'm just Xing out the vehicle. Delete. That's what I'll put. Okay. A Class A misdemeanor carries with it, sir, if convicted, up to 1 year in the county jail and a fine up to $4,000 can also be assessed. Do you understand?
Yes, sir.
The agreement's been reached here. In your case, you would be pleading guilty and sentenced to 120 days in the county jail. You'll be given credit for whatever time you served.
82 days.
Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
Generally, I have to correct things, but I shouldn't be correcting my signature.
Maybe he'll bring you new tablets for Christmas, Judge.
You think Santa? I don't think the sled's big enough for what we need. Show you what's marked as State's Exhibit 1, sir. Did you sign that document voluntarily? Understand it, discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence without objection admitted. This states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You understand what you're charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses, which is what we are going to be proceeding with today. The lesser included Class A misdemeanor of evading arrest or detention. You were giving up your rights to a jury trial, the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true. It states, so help you God. Okay. State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
If nothing further, I'm going to follow this agreement and find Mr. Navajas that you are pleading guilty to this lesser included Class A misdemeanor of evading arrest or detention voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this lesser included Class A misdemeanor evading arrest or detention. I'm following this agreement. You are hereby sentenced to confinement in the county jail for a term of 120 days, and that's 4 months, essentially. Do you understand what has happened today, sir?
Yes, sir.
Anything else? That is all. Thank you.
And Judge, this is a time calculation that I was doing this morning. I don't know if you want it to your file. This is a for Mr. Middenhouse. I didn't know if you wanted it for your file or.
You've calculated the amount of time?
Lacey.
I was told distinctly this job would not require any math.
No, take care of it, right? I run into that every day.
No. What happens is the jail people come up with a determination. We don't, they know, but check that. If it's different from what you think, let me know so we can correct it. We never have to correct it because they calculate it very exact.
I just know you.
But I know we have different, everybody has a different opinion about it because they get time too. I think awarded. So, but if it's something different, I'm telling all defense, let me know if you find out that, that's not what we understood the amount credited to be, but I rely on them, the jail people, and they never seem to make a mistake on that. So, and if it does, I can't remember the last time. So just let me know. And you're probably right.
Well, Lacey did it earlier today, so she's probably right. Most of the time.
There's this. Thank you. Thanks.
Rafael Garcia. He's a motion to vote for vacant.
Well, I hope some of it does come soon. On the tablets, these are just, or we struggle with it. Okay, who is it?
Rafael Garcia.
Okay, we now call 23 CR 2081 Rafael Garcia There's a motion to revoke unadjudicated probation. What are we doing today?
He's coming to you on a read, Judge.
Welcome.
Hi there.
Did you say there was an agreement?
Didn't know that.
Read.
Come on up here. Does he speak English?
It's not, Miss Burge is here to translate.
Okay. Oh, God bless it. Bienvenidos. Welcome. You are Rafael Garcia?
Yes, sir.
Do you speak English fluently?
Yes.
Or you speak Spanish? Perfecto?
I speak.
Habla Spanish perfecto? Sí.
Spanish perfectly. Habla español mejor que inglés.
All right.
Yes.
I have a translator here, and I'm going to ask the translator, please state your full name for the record.
Erica Burge.
And Ms. Burge has a history with our court. She has translated numerous cases, English to Spanish, Spanish to English. She is fluent in English and Spanish, and she is, we welcome her all the time whenever she's here translating. Please raise your right hand. Do you solemnly swear or affirm, Ms. Burge, that you will true and correctly translate English to Spanish, Spanish to English, and this defendant understands fluently Spanish into the language he understands? You will translate during these proceedings so that the defendant can understand and comprehend all the proceedings here. And you will do it correctly, so help you God.
Yes, Judge.
Lower your hand. You are Rafael Garcia.
Yes.
And you were here with your attorney, Ms. Metaldi.
Yes, Judge.
And there is a motion to revoke unadjudicated probation in cause number 23 CR 2081. This was filed October 1st, 2025. Are we ready to proceed?
Yes, Judge.
Raise your right hand. Do you solemnly swear or affirm that you will truly answer any questions, or if you make statements during this hearing, which you may be allowed to do so, you will tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Lower your hand. Can we proceed in summary?
Yes, Judge.
In summary, this motion to revoke unadjudicated probation states that on July 31st, 2024, in this court, you, Rafael Garcia, was placed on 10 years deferred or unadjudicated probation for evading arrest or detention with a motor vehicle, which is a third-degree felony. Is all of that true and correct?
Yes, sir.
Allegation 1 in the motion states you failed to report to the probation office, the Jefferson County Probation Office, on or about September 4th, 2025, which was in violation of your probation order, which required you to report to the probation office regularly. Is all of that true?
Que no se reportó específicamente. ¿Es cierto? Yes, Judge.
3 states you provided a urine sample to the probation office as required of you on August 21st, 2024 and September 18th, 2025, which showed the presence of tetrahydrocannabinol or marijuana in your system.
Your Honor, I heard you state 2024 on the first date. Should be
August 21st, 2025 and September 18th, 2025. You provided a urine sample to the probation office, which showed the presence of marijuana or tetrahydrocannabinol in your system, which violates an order or a condition of your probation. Is all of that true?
It's true.
Is that good? 1 and 3?
Yes, Judge, whatever your preference is.
My only other concern was count 2, Judge. And that's,
What do you want to do?
I would prefer a plea on that, Judge.
We failed to report the next day as well. From that's September 4th and September
So
5th.
he failed to report on 4th, but he had a jail sanction and failed to start. That's the difference between counts 1 and 2.
The count 2 of the motion to revoke probation alleges that the defendant failed to report to the probation, I'm sorry, to the Jefferson County Correctional Facility, the county jail, on or about September 5th, 2025, which violates his probation order. Is that true?
He says that's not true because I did appear.
All right, let's, y'all sit down. We'll have a hearing. We'll have a hearing on it. Okay. Go ahead. Y'all get ready to out. Let's hear it. Who says it's not you?
No.
No. He's gonna, you need to sit with that, sit over here with your lawyer. We're gonna have a hearing right now. Sorry, gotta finish this. We got 1 file at a time to put out. Okay. Stay.
We call Stacy, Miss Stacy Chapman Bradley.
Please raise your right hand. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Please have a seat. Man, okay, thank you.
Yes.
Go ahead and state your name for the record.
Stacy Chapel Bradley.
You need the mic adjusted, or you've got it, Judge, right? What do you do for a living, ma'am?
Excuse me?
What do you do for a living?
I am a Jefferson County probation officer for the high medium risk caseload.
And were you assigned an individual by the name of Rafael Garcia?
I was, sir.
And is he currently still on your caseload?
Yes, sir.
Do you see him in the courtroom here today? Can you point to him and identify something he's wearing?
Long black hair and a gray jumpsuit.
Gotta make the record reflect she's identified the defendant.
Yes, it would.
All right, so let's just jump to the condition that he's pled untrue to. The accusation was he alleged to have failed to report to the Jefferson County Correctional Facility on September 5th. Was he ordered to do that?
Yes, he was.
Of this past year, or this year?
Yes, sir.
Right, thank you, Judge. So we're talking about September 5th of 2025,
Yes, sir.
roughly 3 months ago. How was it that he was ordered to go to the jail, man?
He was ordered when we had the administrative hearing and he was given paperwork to sign to report by 5 o'clock on September the 5th. He was also supposed to come in the 4th to get further instructions about what he could take or anything like that. But he was told specifically to be there before 5 o'clock on the 5th.
And who gave him those instructions?
I did.
All right, so am I reading the information here correct that was because of an administrative hearing held on August 21st?
Yes,
And you gave him the instructions on that day?
On the administrative hearing, yes, sir.
Okay, so we've had a subsequent administrative hearing since that date where he didn't report on the 4th to talk to you all, and he also didn't report to the jail on the 5th, have we not?
Yes.
And did he make a claim that that he had gone to the jail?
He did. He stated he had gone approximately at the nighttime around 10, 11 o'clock.
Is there any chance that your instructions to him were unclear about what time to be there?
No.
Does it make sense to you that someone should turn themselves in at 11 PM as opposed to before 5 PM?
No, sir.
And so when you have a scenario where you order somebody as sanctions to go to jail, I know y'all do a lot of weekend sanctions, don't you?
We do, sir. We try not to, but we do. Occasionally.
They exist, right?
Exactly.
So whenever you show up on Monday, do you call or do you do some form of check to determine if the individual went in?
Yes, sir. I test the Odyssey system and see if they've been admitted or released over the weekend.
So you do that routinely no matter what, right?
Absolutely. Here we go on those things.
So specifically, did you check to determine whether or not Rafael Garcia turned him in to the jail on September 5th of 2025?
He did not.
And was that verified when you returned to work? I'm going to be cautious. That may have been Labor Day that followed that Monday after. All right, so let's assume the Tuesday after. Did you determine that whether or not he went to jail?
I did, sir.
And Odyssey showed what?
He had not reported.
Is that the system that you use determine then?
Yes, sir.
All the evidence I have as to that violation, Judge, a pass the witness.
Good morning.
Good morning. Good morning. Yeah.
You mentioned that my client was told to report to the jail on that September 5th of 2025. Is that correct?
Yes.
And he was told to report at 5 PM.
By 5 p.m. Yes.
At 5 PM. You also mentioned that he did report to the jail just later than that time.
Yes.
Correct. So he did report to the jail on September 5th of 2025.
According to him, yes.
Not by the designated time period.
Right.
And then you also stated that you were the one who gave him those instructions to report to the jail, correct?
Yes, and this guy was present. My supervisor.
I'm sorry, say that last name again.
Supervisor McGallion.
Okay, sorry. I kind of heard or came out like it was my last name and I was like, that is not what I remember. Yes. Okay. So you do see in the courtroom today that my client is using an interpreter, correct?
Right.
And through this proceeding, Ms. Burge has been translating this proceeding to my client today, correct?
Yes.
I have no further questions, Judge.
I just want one thing clarified. Did the jail tell you that he reported?
No.
The source about him reporting is him,
Yes.
right? And when you check the information, Odyssey didn't indicate that he had reported, did it?
At all.
So us volunteering to the judge is that he advised you that he was there at 11 o'clock. And that's not affirmed or confirmed in any messages, no systems, no individuals laid eyes on that.
No.
And that would be against your instructions to him.
Yes, sir.
No further question.
Don't come on up there. Back up. Yes, sir.
You can set that.
Where's the defendant? Come on. Anything else to add as to that allegation too?
Not from the state judge, no, sir.
Judge, my only I suppose addition to that is that during probation meetings, he does not have somebody that translates information for him. My understanding is that his English is basic enough to have a basic understanding of things. However, for a more concrete understanding, I think a translator is necessary, which is why Ms. Burge is here today.
When did the defendants get placed into jail ultimately? When did he finally find his way into the jail, and how did that happen? Was he arrested or?
He was
It was
arrested in TRP.
But what day?
I'm sorry, sir, about the day of the jail, went to jail.
You may or may not have it. If you don't worry.
I don't know that just time.
This motion was filed on October 1st, so I'm assuming sometime shortly after that, but I don't have a good date for you, unfortunately.
You're saying your client was arrested from the motion to revoke probation?
That's correct. A warrant would have accompanied that
All
motion.
right. Anything else? The court is going to find that the defendant has pleaded true voluntarily and knowingly to allegations 1 and 3 of this motion to revoke unadjudicated probation. That is enough to grant this motion to revoke probation by a preponderance of the evidence or greater. And I grant this motion based upon those findings of 2 violations, the failing to report to the probation office and failing to and providing a urine sample which showed that he had marijuana or tetrahydrocannabinol in his system. Those are violations of condition 4 and condition 6 of his probation order. Now, what do we do? Pre-sentence, is there a pre-sentence report?
Yes, sir. And jail records show that this man was arrested on October 23rd. He's currently working on 54 days credit.
This is his only criminal history.
It is.
Okay.
And the underlying circumstances for the offense are bizarre, for lack of a better word.
They didn't drug test him that night, did they?
I don't believe they did, Judge, but there was, I mean, they're odd enough that I actually remember it before without actually looking at the file. So that says a lot.
Unfortunately, I don't have access to that because I didn't handle the underlying case. It's just added on to the motion to revoke the motion. So I'm unaware of the.
Okay.
I personally would like to see him succeed. I think that he's just off to a really bad start with not doing what the probation has suggested.
What was state requesting?
The reason why I made a pen time offer to his lawyer is because from reading through the administrative hearings, it looks like the probation office has already made multiple accommodations to him as to each interaction that they've had with him. And at some point in time, we've got to make a decision to say, okay, you're not taking this probation seriously.
Okay.
So like I said, I would love to see him succeed and complete this probation, but it doesn't matter what I want, it matters what he wants. And from what I can see, he's not taking this stuff seriously. He's not doing what they're asking him to do. And he may be blaming the language barrier, but I don't think that's what it is. Because my probation officer tells me that she's able to communicate with him without any question about whether or not he understands.
In English?
I do. We've had conversations. We've told him to be. We've had speak slowly and slowly. And we do conversation. And I do, if it gets complicated, and he feels like, I feel like he doesn't understand, I call in somebody, but that's been happening one time.
Go ahead, defense.
Judge, we would obviously prefer to see him succeed on some form of probation as well. I think his lack of criminal history and his age that he's currently at is something to be taken into consideration. He's only 19 where he stands right now. He does not have any other prior felony convictions of any kind, and he has expressed to me that unfortunately he seems to be the type to learn his lessons the hard way. And from this 52 stint of being in custody in Jefferson County Jail, has showed him that that's not a place that he wants to be or spend real time at. Marijuana was a vice for him. He expressed that to me as well, saying that he fell on hard times, wasn't able to find a job, was working through some things, and that was something that he resorted to and that he has a problem with. So my recommendation or my request would be some kind of JDCI conditions be added to his probation so that he can try to work towards being part of that successful 93% of Jefferson County probation. I'm asking for his deferred to be reinstated or at most for his probation to be switched to a straight probation so that he can continue on supervision and rehabilitate.
I didn't hear what the state's bottom line was on this.
So prior to today, Judge, I had offered 4 years TDC, and I've been real candid with the court about that. It has everything to do with my perception that he's not willing to do what they keep asking him to do.
And that's what you're asking for.
Unfortunately, that's where I still stand.
Mr. Garcia, do you want to say anything to the court?
No.
Okay. The problem is we're talking about failing to report, which is very important. If you don't report, you're not on probation, really. And committing a crime, illegal possession of a controlled substance, namely marijuana, tetrahydrocannabinol, is a crime. Those are serious. You got in trouble for committing a crime. You know, and now you're committing another one here. And which the court is going to find that the defendant has pleaded true voluntarily, knowingly, intelligently to allegations 1 and 3 of the motion to revoke probation. That is enough to grant this motion to revoke unadjudicated probation by preponderance of the evidence or greater. And thus, I approved the motion, and the defendant's deferred or unadjudicated probation that he was on is revoked. Earlier in the case, the defendant pleaded guilty to the 3rd-degree felony of evading arrest or detention with a motor vehicle voluntarily, knowingly, intelligently. There was sufficient evidence supporting his guilty plea at that hearing to find him guilty beyond a reasonable doubt. I now find you, Rafael Garcia, guilty of this underlying 3rd-degree felony of evading arrest or detention with a motor vehicle, and your deferred or unadjudicated probation is revoked. You are convicted of this 3rd-degree felony and sentenced to 2 years in the institutional division of the Texas Department of Criminal Justice. And that is a conviction. I wish you would have been successful. All right. Anything else? That is all.
Next, Judge.
Thank you.
I have a Preston Simon on here. And who is that? Who's got that?
Lane.
Who?
Mr. Lane.
And then Caleb Baker, we already did, right?
No, we didn't.
No.
That's Caleb Baker.
Okay, Caleb Baker. Who's got Caleb?
Mr. Caleb.
And who are you, sir?
Preston Simon.
Who's your attorney?
Brian.
Who?
Mr. Lane, Brian Lane.
Where's he?
What's your?
Location. Okay, we can't do anything with that. He comes in handy. We gotta have him here, okay? Yes, sir.
I'll pull me just for Simon to come swear in front of you, fingerprints. What's that?
Thank you.
Raise your right hand. You start off right in front of the You want yourself to find. You get your right thumb print. Okay, place it flat right here.
Hey, Reagan,
You can carefully yourself.
this Douglas was reset, huh? Yes,
That's correct.
Douglas was reset.
Yes, Judge, he has two more cases that are waiting.
Okay. And then the other one was Rafael Garcia. Let's see, I have Ashton Spearman.
That Giles Cole is covering the motion to revoke probation.
Is that what he's here for today?
I think you approached and you reset
He
it.
did. You reset it for me.
Set a motion for.
Ashton has been reset.
But there's something I need to figure out to see if Giles is covering the two new cases as well, or if it's just the MTRP, that I'm not sure on yet, but either way, it would be after the revoke probation hearing.
Okay.
May I have excuse?
Yes, ma'am.
Thank you, Judge.
Brent, you got Rodney Cleveland, among others.
Should be like most separate as four cases, so it's just.
Okay, we're having hearing on Rodney. Then for hearing on NPRP.
Judge,
Yeah.
the revocation is basically split into two parts. The first 3 or 4 allegations are based upon a new case that the state hasn't filed yet, or they got the labs back.
We're still waiting on the labs. They're still processing.
What do y'all want to do today?
I would ask for a reset so that we can wait on, get those labs in.
Yeah, where is he?
He's in the, I would, and then we would ask for a bond in this condition, considering the states, we're approaching 90 days on the new allegation, and then it is an unadjudicated revocation.
All right, bring him in. Here's what I'm gonna do. We're gonna go on what we can do today, and then I'll just make a ruling based upon what we have. Yeah, Rodney Cleveland.
To go to the other side.
The other side. The other side. You're not talking about communism or anything. Versus democracy. I don't want to go to the other side.
It's of the hall.
Yes, it does.
The other is,
Administrative.
yeah, and he's still got like 9 years left to do this, Judge.
There was no agreement on this, right?
No, Your Honor.
Okay.
No, that's what we were
So you agree with that?
kind of waiting to find out what happened with the.
We're going to move forward with what we have. Let me see the pre-sentence report, please.
Your Honor. Let's see if it was shared with you.
At approximately 1:30 a.m., Officer Cormier was dispatched to 17148 Geranium Drive on a report of a domestic dispute. Our dispatch advised female caller, Miss Farad Azim, said her husband hit her and she needed to go to the hospital because her hand was possibly broken. Upon arrival,
Oh, Bob, you don't have to post any money.
I explained that to him.
okay, I get it. Okay.
It's that promise to come back or you forfeit that amount.
Yes.
I'm doing all these, the felonies here or what?
I'm ready to go. I have,
People against Blake Maurice Morrow the third, 25B 7279151 FY.
Mike Baldwin, arraignment attorney. Judge, today's the date and time set for arraignment. For purposes of arraignment, my client stands mute and waives formal reading of the general information.
Sir, your name?
Blake Maurice Morrow.
All right, good morning, Mr. Morrow, or afternoon, I suppose now. I'm going to go ahead and arraign you. Your lawyer indicates you stand mute. You have a charge of home invasion in the second degree, which is a 15-year felony and larceny in a building. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. Do you understand that?
Yes, sir.
You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. The probable cause conference will take place 1 week from tomorrow, which is the 23rd of December. And the preliminary exam will be December 30. Somebody go down here December 16th at 9:45 for the PCC. And then December 23rd for the exam. I'm arraigning a felon right now. Well, they must have just made a mistake, right? The 16th tomorrow. So I mean, prosecutor's office is still going to be here both those days, right? Okay. Thanks. Okay, so I'm going to do the 23rd at 10 o'clock. Preliminary exam will be the 30th. At 11 o'clock. All right, now we're going to address bond. What do you have to say?
Very briefly, Judge, my client's 20 years of age. He's going to be 21 in January of next year. He works at Anthony Pierce Concrete. He's a laborer. He's a seasonal layoff at this time. He is taking care of his minor niece who lives with him. He is a resident of Monroe. He also resides with his girlfriend, the client's girlfriend, who has 2 minor children as well. His highest level of education is the 11th grade. He has no additional credentials. However, he is certified as a high-load operator and pallet jack operations. He was born and raised in the Detroit area, and he does not hold a valid driver's license. He's never acquired.
Detective, what can you tell me about this? Was there any kind of relationship between the defendant and the victim here?
Your Honor, to my knowledge, I believe they are related.
We're sister and brother.
Sister and brother, Your Honor.
I have like text.
Sir, you shouldn't say anything, sir. Okay? You shouldn't say anything. Do you want to add anything else? Do you know what this was regarding, Detective?
Your Honor, it was regarding stolen property. This is Detective Tulot's case. She wanted me to make note that there is some criminal history out of Ohio. Nothing out of Michigan here.
Where's our
victim in the case? Our victim in the case does not want any contact and has since moved from her address that's originally listed in this warrant recommendation.
And that's in the advice of rights. His new address and phone number is in the advice of rights. That's updated.
So he wasn't living with her at the time. He just broke in and had the intent to commit a larceny. Am I reading this right?
I believe so, Your Honor.
20,000, 10%. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No contact with Cinnamon Warren. No contact with prosecution witnesses. You cannot enter 22910 Bernice Court in Brownstown. No marijuana, no alcohol, no illegal drugs. You're not to possess firearms or dangerous weapons. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We will see you here next Tuesday. You have to post $2,000 to secure your release. Okay?
May I say something on behalf of my client at his request, realizing we had factored in that the bond was going to be in this area? Would Your Honor consider a lower bond with a GPS tether?
Where does he's a seasonal employee?
He is laid off, but what he does is he does concrete laying during the season. He is a lifelong resident, Judge, of the state of Michigan. He was born and raised in the Detroit area. He is taking care of his daughter, who's 7 years old. He's the main support.
That's me. That's my niece. That's the other client I'm being told here.
So if Your Honor would consider a GPS tether, that would be a big difference for him to be able to get out and take care of these children that he's also licensed.
What can he post? Can he post 10? Can he post 1,000?
I did speak to it. Can you post 1,000? It's your lawyer.
Honestly, I gotta call my stepdad. I gotta
10,000, 10%. Hang on. I'll not to be released until fitted with a GPS tether. Not to be released until fitted with a GPS tether. And you're not to be within 2 miles of the victim, her residence, or place of employment. So I'll reduce it. I'll go down to 10,000, 10%. So you have to post $1,000. Wish you well. Thank you. Good luck. Bring in Mr. Whittle now, please. This is Timothy Jamie Whittle, 25B14837-9A, 25B14837-9B and C. And I got 21F235726A. And I've got 25T645972A, 20B137-133A. And 20B13708OB.
For the record, Your Honor, bereavement attorney Mike Baldwin, he's 65417 on behalf of Mr. Timothy Whittle on all of these files. For purposes of arraignment, my client stands mute and waives formal reading of the general information and complaint. His updated address and phone number are in an advice of rights in each one of the files.
Tell me your name, Mr. Whittle.
Timothy Jamie Whittle.
Going to take me some minutes to mark these up. I don't even want to say anything right now. You must be a big shot, though.
Just trying.
I'm just telling you, you must be a big shot. I mean, you must be running the you must be the Secretary of State, Chief of Staff to the President, something important. I mean, you have to be really, really, really important. You have to be. Because there's no way that somebody would not show up unless they're doing something really, really important. So we're going to find out what that is. And then I'm going to proceed accordingly here. But you do not, Mr. Whittle, you do not endear yourself to any judge in the country by acting like this. Do we understand one another?
I understand.
This is the old cases we talked about, Mr. Whittle, you and I as your attorney.
I mean, I'm so curious as to what he does for a living.
I don't know.
I want to do something that important. I mean, you have to be important. I mean, minimum, you're an athlete making $222 million over 4 years. I don't know if you're a shortstop pitcher. I don't know if you're a guard in the NBA. I have no idea. But you have to be doing something so incredibly important that would cause you to not show up. And I'm just getting started here. I mean, I want you to know that. We're going to have some fun now, Mr. Whittle. Who do you think you are? Who do you think you are? And guess what? I don't care if you make $50 million a year as a professional athlete. I don't care if you're Secretary of State. I don't know who you think you are. It's amazing. I mean, you have just managed to prove you got to be doing something important. You got to be doing something really, really important. I want to repeat myself 19 times before I set your bond. I mean, you picked the wrong guy to play this kind of nonsense with. I need some light on. I mean, I'm just always amazed. Just completely amazed that people think they can do this. Now, so he stands mute on all these cases, right? He's got at least 7 of them.
He has 7, Judge. He does stand mute, waits formal reading the general information and complaint. I've gone over each of the general information with the client. I will note he's had bonds. They've been forfeited. There's been financial bonds in the file that have been worked.
No. We have the audacity to forfeit bonds? Are you kidding? Are you kidding me? We did that? Guys like, people like us did that? It must be bad over here. Tell me what he does for a living. I'm curious.
Judge.
Tell me. Is he an
Yes, he
all-star?
works at Sam's Club, Judge, in Tepe, Michigan.
Sam's Club. Okay.
Yes, he's also.
I thought he owned all Sam's Clubs to act like this, but go ahead.
He's also enrolled in Washington Community College. He starts.
Why would he do that? Why would he do that?
To better himself.
I feel like setting this case with a bond and setting it for like, he's got a 2020 case he pled guilty on March 5 of 20. He didn't show up on that 3 or 4 times, then didn't show up for his sentencing in December 21, then posted a bond. And then on April 26 of 23, he didn't bother showing up. Then it looks like he posted another bond. Let's see. And then, or somehow he canceled the warrant. I don't know what happened. Then August 13th, he didn't show up of 25. That's just on one case. On the other case from 2020, March of 20, we never even adjudicated that. He didn't show up for pretrials after forfeiting bonds and not showing up. And another case we had here out of the metropolis of Trenton, where he didn't show up in August or for the show cause on the second time. And then he had other cases out of Brownstown, possession of controlled substance that he didn't show up with from 21. And then another one out of Brownstown. Yeah, same thing, suspend and false information. And, so I just want you to know, this does not enthuse me. Because this just tells me flat out that somebody's just plain out, flat out arrogant. That's what it tells me. But I won't belabor the point. You can go on and tell me, because he's going to be sitting in jail. I mean, I don't know what kind of bonds I'd have to set. He'll post and then he won't show up again, like a fugitive. You want to be a fugitive, Mr. Whittle?
Your Honor, I promise I'll show. If you show any type of grace on me today, I promise I'll show.
Don't listen. Show grace on you. Give me a break. I have a mind to set about 10,000 in bonds and set.
Here now.
Rodney Cleveland Chamber?
Yeah, that's me. He must have slipped in. He must have.
We'll just reset it tomorrow.
Sorry.
We'll just,
It might have to be one thing. I'll double check.
okay. Well, that'll be,
I'll do the best we can.
Okay.
all right, Lydia Stanford.
Yes, Judge. Do you mind switching on the stat real quick? Something hold.
Hold on.
Daniel got.
I don't have Lydia Stanford's.
What's the other part of the?
Never has 4 cases, so it's.
Probation has upped that to 24 months, and also was requesting a GPS tether. Given that there is a no contact order currently, if the court changes the contact from Ms. Everett's request today, then the GPS tether on the recommendation.
Mr. Coyle, is there anything you want to tell the court before I impose sentence?
I regret everything that I have done. I have full remorse.
I'm sorry.
I said I have full remorse of what I have done.
And Ms. Blair, you're indicating that with reference to that bond violation, you've taken that into account in terms of the sentence.
Yes, I did, Your Honor. I originally had recommended, when I spoke with Mr. Coyle during the PSI, I did indicate to him that I was recommending an 18-month for a deferred, given he has no prior arrest or conviction. Given that there was that bond violation, my recommendation to this court has changed.
All right. Sentence of the court, 24 months deferred sentence pursuant to section 7694A of the Spouse Abuse Act. You are to pay $555 fines and court costs, $720 probation oversight fees. Do you know when you may be able to pay that?
I have to, my parents are willing to pay for that, so whenever I can pay for it.
What I will indicate is that's to be paid within 30 days after release. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a domestic violence program as directed by probation. There is to be, I will lift the no contact provision. I'll indicate no non-consensual contact with Sally efforts. You understand that, sir?
Yes.
You understand what that means?
Yes.
All right. I'm going to strike, given my change to number 6, I'm going to strike number 7. There is to be no, you are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You are not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to comply with any and all circuit court orders, if any. I will not place the defendant on a GPS tether, given the change in the condition in number 6. I'll set a review hearing on this matter to be held February 9th, 2026 at 1 p.m. I will order 93 days in jail, credit 11. The balance is suspended. With reference to any move to Florida, he'll have to give details to probation and then we'll make a consideration regarding that.
Thank you, Your Honor. Thank you, Your Honor.
Thank you. Pardon?
The next individual is.
Yeah. Court does call the case of People versus Kyle Wilson.
Alexander on behalf of the people. Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Wilson. Mr. Wilson, please state your name for the record.
Kyle Wilson.
Your Honor, we did review the pre-sentence report. I'm sorry, was the court going to indicate something?
No.
Okay, I thought.
Want me to?
No, I thought I was
I mean, I can
interrupting
say
something.
if you want me to.
I apologize.
That's the first time ever you stopped. Something to say. Go ahead, Ms. Finch.
Just trying to read the room for once. Your Honor, we did review the pre-sentence report together. We don't have any material changes, additions, or deletions. I also reviewed the sentence recommendation with my client, and we ask that you adopt it.
Your Honor, may we approach?
Yes, you may. I was actually going to ask that you approach.
180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes.
Yes.
Signing as we speak, or tell me that.
You should have it now, Judge.
Thank you. An agreement has been reached in your case where you would be pleading guilty and sentenced to 9 months in the state jail. Is there any loss here?
No, I believe all the items were returned.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, sir, you have no right of appeal of your case. Do you understand?
I did.
How do you plead to paragraphs 1 and 2 here? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Paragraph 2. Paragraph 1 states you committed theft, that you pleaded guilty to. Paragraph 2 states you have 2 or more prior theft convictions in county courts at law or district courts in Texas. And are those allegations true and correct in paragraph 2 as they are alleged? And are you pleading true and correct to that voluntarily and because those allegations of prior theft convictions are true?
Yes.
I'm going to show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it. Discuss it with your attorney. Are the contents true and correct?
It is.
State's Exhibit 1 tendered into evidence.
No objection.
Without objection admitted. This states you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, please.
I'm going to follow this agreement and find you are pleading guilty and true respectively to the allegations in paragraphs 1 and 2 constituting the state jail felony of theft. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty of the state jail felony beyond a reasonable doubt. I so find you guilty beyond a reasonable doubt. I am following this agreement. You are hereby sentenced to confinement in the state jail for 9 months. You will be given credit for all time you have served in accordance with this case. Do you understand what's happening?
Yes.
Good luck. Thank you. I thought this on last month.
All right, people like that have come through on how it died, and I, you know,
Thanks. Izzy Lantern.
That's going to be second on.
That's
I'm sorry. We already did that.
Yeah.
Jorge Perez was Matthew.
He's working on it.
That's what John said.
I think it was signed up for writing, but I don't know what writing said.
Matthew Rogers, we already did. Correct? Clemente Hernandez, we did.
Yeah.
Danny Johnson, we did. We did that, right?
Yes, sir.
Tori Morgan.
Please play.
And Brian was on Preston. Simon, we took care of. And let's see, I have Jorge Perez.
Yeah, we need to set that for a hearing. Me and Mr. Boyd have talked about that.
Okay, when can we do that?
Hey, yeah, that's pretty quick, but
Yeah, that's probably we need.
Later this week? No?
I got a bunch of stuff to say this week.
2 weeks.
Well, this is one of them.
There's still already scheduled. First docket, we need to after the first of the year.
Yeah, because we'll have.
All right.
You guys need some
Jorge
people.
Perez.
So yeah,
First week.
okay, whatever.
Okay, Caleb Baker.
That's a plea.
Supposed to be please ready to be go, Judge.
Yeah, well, maybe Shelby Smith
I've been waiting for Ryan to see what happens with that.
and Ashton Spearman.
That was taken care of.
Okay, this is 2, Smith and Baker. There's here. Sorry, that's it. We're done. Nobody, he's not here.